Item 41.
Yes.
Pay for adjournment, brother.
You are seeking adjournment.
41. Item 41.
Yes, you are seeking adjournment.
Page 6.
You are Mr.
Behera.
A.K. Behera.
Again.
When do you want, sir? Kebe chahuchundi?
Next week.
अच्छा एटा कोन रेगुलर असाइनमेंट तो बोधे नो एटा रेगुलर असाइनमेंट टू दिस कोर्ट
No.
mention for listing before the assigned bench खाली अपीयरेंस ता लिखा हेले ए ऑर्डर ता सबुटी लिखा हबो
Oblige.
यस 41 तापरे
My lord,
Item number 18, my lord.
हां
Maybe next week, my lord.
एटा अपन मोर एटा रेगुलर असाइनमेंट नो जोडा टायर्ड अप थिबो सोडा नहले अन्य मैटर जोडा केमति अन्य कोर्ट लिस्ट करै देबी कुछ करछन आई अंडरस्टैंड एट टाइम्स यू आर फेसिंग डिफिकल्टी फॉर लिस्टिंग बिकॉज जोडा हेवी असाइनमेंट कोर्ट रे रहउछि ना तेनु तापरे आपण गोटे दिन लिस्ट ला मो पाखरे मु ता सो आई कांट डायरेक्ट लिस्टिंग इन द अदर बेंचेस
Next week, my lord.
so no you move the 18 same I hope you understand what I am saying. Let us not waste time already. The things have been very hectic last few days and today also already it is at some meeting and now it is we are at to start with I had a meeting.
my
Adjourn, only adjourn.
Liberty to mention I am granting. So you mention before for listing for assigned bench. Don't upon sorry I am so sorry please upon na
BB Acharya. Vishwavijay Bakshi
Acha.
Acharya.
Vishwa Vijay Bakshi.
Bakshi Acharya. Bakshi Acharya. Vishwavijay Bakshi.
BBB no not BB is BBB. Good.
My lord.
BBB Acharya 18 रे अपन लिस्ट लिख दो ना नंबर पर लिखছো ठीक है
My lordship.
18 एपटे गवर्नमेंट रे के अछन यस मिस्टर दास 18 अच्छा ठीक अछि से मु जेमति करे वो लास्ट डाकी ऑर्डर आई एम नॉट पुलिंग आउट एनी फाइल टू कॉल सो जो यू यस मेंशन
My lordship. Item number.
my lord, item number 6 kindly permitted to withdraw.
6
Yes, my lord.
reason
My lord, the petitioner does not want to press the bail application with liberty to move the learned court below after.
memo दियंतु
Yes, my lord.
Mr Panda you are there
Not
अच्छा
present.
you
He's not
are not an associate of Mr Panda your name madam
Mona Lisa Mohanty.
who has signed the memo
Sir,
करचंती
yes.
would never withdraw a memo at the instance of your I mean the appearing counsel or the advocate on record.
Yes.
It's a very serious problem. They don't.
Obliged.
My lordship. Item.
एटा आपण मूव करिवे को कोर्ट कोचंती एटा त आगु एठी रिजेक्ट हेतला
Move to learned court below. Court below.
केमति करी प्रधानी जानी कुशदुर्गा पढिचंती सुप्रीम कोर्ट कहले जो कोर्ट रिजेक्ट करथिबे से कोर्ट को जिबे हायर कोर्ट has rejected I will move the lower court unless change in circumstances like filing of charge sheet and you have to specifically mention that since charge sheet has been filed in the meanwhile I will move the court for bail in session court in session for bail because otherwise this Pradhanijani and Kusoduruka are binding on that court also. Start reading these things. Don't be blank. I'm just discussing, encouraging you to study all these things. These are the other aspects of withdraw, dismissed as withdrawn. Nothing more than that. I do not know what you will do after that.
Liberty, my lord.
How can I grant liberty on the face of Pradhanijani and Kusoduruka if there is no change in circumstances?
Hello.
When I ask you change in circumstances, you must answer me that.
My lord, file a fresh applications, my lord.
No. Fresh application like kisi bar nahi seta. I would a problem.
My lord, witness.
There is absolutely no bar for filing opt-in number of bail applications. That is not contemplated in law.
Witness examine more witness examine about my lord.
That's another thing. You can always, that liberty is not required at all.
My lord, kindly permit.
No, I don't understand what you are saying. That's the difficulty. You ask your senior to come. That will be better. Please don't take that chance. आपण काय risk नौचंती.
My lordship,
Yes.
item number 26.
Pass over ହେଇଯିବ ଯଦି ବି ନଥିବେ ଆପଣ last ରେ କରିବେ. କହିଦେବେ senior को. Whenever he comes, the matter will be taken up. Yes.
Lordship,
Item number 26, your lordship.
26.
Some other day.
Your name, sir? I've forgotten. I'm sorry.
My lordship, G. Chaitanya. Gyanendra Chaitanya.
Gyanendra.
Gyanendra Chaitanya.
G. Chakra.
G. Chaitanya.
Acha, G. Chaitanya, sir.
My lordship, on behalf of Mr. Vishwabihari Man.
That is how I'm asking. You are not Vishwabihari. There is some commonality. What is the commonality? Between you, Vishwabihari sir, and Mr. Bishwal. Discuss and come back. Yes.
Some other time.
Yes, yes. Urgent. Urgent with liberty.
My lord, item 12/16. Permit to withdraw, my lord.
You are Mr. Samal.
Biswajit Lenka, B Lenka.
Mr. B. Lenka. Memo douchunti.
Again.
Dismissed as withdrawn.
Again.
Reason call लिखिले.
Permit to withdraw. File a fresh application before the
Retrieve called fresh application.
before the appropriate authority. It haboni sita.
अच्छा ठीक है.
Again. Before appropriate authority.
दियंतु मेमोटा दियंतु लिखि नंबर टा लिखि दियंतु.
Item 30.
सर अरे गोटे सॉरी नहीं आपण मिस्टर लेंका पळेल चालीबा आरंभ कले. आपण एट ए टाइम दुटा तीनटा मेंशन करिवे गोटा पर चलीबे. 12 पर केते?
12 पर 16. 16.
सॉरी नहीं. सेटा भी से है.
Again.
16 ने कोन ऑर्डर अछि देखियो पड़ियो.
এটা ଗୋଟେ ମଗା ହେଇଥିଲା ସେଟା ସର୍ଭେ ସେଟଲମେଣ୍ଟ ରେ ମ୍ୟାଟର ଟା
अरे सर्वे सेटलमेंट जे तांकू फेर तो पचरे पड़िबो ना आपण अदर साइड ना सी नॉन एग्जिस्टेंट लॉयर तांकर किछि ब्रीफ नहीं कोर्ट नहीं गाउन नहीं यू विल हैव ए राइट ओवर देम. अच्छा टू ऑब्टेन इंस्ट्रक्शन किछि इंस्ट्रक्शन 16 रे आछि की ठीक है आपण मेमो दियंतु देखिबा सेमति वी कांट प्रीएम्प्ट आपण मेमो लिखि दियंतु.
Item
And
30.
also treat them as lawyers also. They are holding a brief. They have something to say. So,
Item
Things.
34 and 35 and 46, your lordship.
sorry,
Item 34, 35 and 46,
34.
my lords.
34.
35
J.
and 40.
Bishwal. We done.
No, your lordship. I prefer adjournment.
Adjournment. 34.
35 and 46.
सकाल सकाल विड्रॉ कले डिस्पोजल स्कोर बढ़िबो ना त किछि. 34 adjourn. Adjourn. With leave to liberty to mention.
My lord.
Yes.
your lordship item number 10 your lord
34 to 46.
ठीक है ठीक है. 10 की कहले.
item number 10 your lord
Sorry. 10. Mr. Chwal Singh or Nayak.
no your lordship I am submitting on behalf of Mr. M.K. Ponda your lordship my name is Sirish Chandra Tripathi your lordship let the matter be taken up after 1 week
ठीक है. आपको ना पावर नहीं.
again pawan nahi
On behalf of Mr. Manoj Panda.
M.K. Ponda yes your lordship
Adjourn.
yes your lordship 1 week capital lordship
आया.
oblige
जेबे को चाहिए मैं मेमो
Oblige,
देबे
Lord.
लिस्ट. हां नेक्स्ट
Item 5.
5
Permitted to withdraw.
रीजन
Reason is that matter in the meantime acquitted by the runners.
टी अक्विटल डिटेल्स दे दी चंती.
ना डिटेल्स हम पका नहीं आई टॉप
अच्छा.
मैनुअल रन ट्रायल कोर्ट एडवोकेट कल्ली
ताले ना मो इंस्ट्रक्शन मागी की एटा कर दो एटा हे जो मेमोटा कि दियंत.
मेमो दे
आई विल कॉल फॉर इंस्ट्रक्शन.
may I pardon my lord
विड्रॉन. सुजना. Yes please.
item 3 my lord
Yes please.
and permitted to withdraw my lord
Reason convicted.
no not convicted the petitioner does not want to press the matter to face the trial
Mahapatra, how much time it took you to decide this? Almost 3 months. You have.
my lord I am in a presumption that your lordship
I understand, but this I have been discussing with you patiently. Dion.
Last occasion has
ज्ञानेन्द्र त्रिपाठी किए अच्छा से मिस्टर आपड़ रही ना अदर सीट कि जानवे आप आसी तो आपियर करेंगे नोटिस जाइए अपेक्षा करूँ दिखाँ तीन भी मेंशन करेंगे से जानवे केमती
Item number 1, my lord, permitted to withdraw, my lord.
जस्ट ए सेकंड अब लिस्ट कॉल हबनी कि अरे एड्रेस करंतु कोर्ट को समझ कोन चालू छंती कोन आइटम 1 पर डाकिले
My lord, permitted to withdraw, my lord.
काहे की
That doesn't want to press this, my lord.
why it has been listed before this bench sir
A co-accused has been already released by this court, my lord.
what is your status
My lord, charge sheet has been submitted and some of the witnesses has been examined, my lord, in this case.
he is in custody
My lord, I have contacted the lower court advocate, but he did not receive my phone, my lord, since.
काहे रिस्क नौ चंती कुशदुर्गा परे it will be referred to bar council of india
My lord, I have filed the
अरे
withdrawal.
तार माइलॉट कोन करिए मु कोन बार काउंसिल प्रधान जानी कुशदुर्गा पढ़ी चंती
No, my lord.
पढ़िबे ना आपन ना सर
Durga Datta Mahapatra, D. Mahapatra, my lord.
सडी दियंत मेमो दियंत ଆପଣ ଲେଖଛନ୍ତି list in the sitting of this bench after 2 weeks ଛିଡ଼ା କାଇଁ ହଉଛନ୍ତି ମୁଁ ଏଟା ଡିକ୍ଟେସନ ଏଟା ଦଉଛି ଏମିତିଆ he and me both are from same school were taught by the same teachers English but he has forgotten names of all the English teachers list after 2 weeks oblique when this bench sits next कौन लिखले list in the sitting of this bench अपन standing of the bench रखना कौन order day number 2 dated 9/2/2024 सेटा लिखिए आगे लिखंतु the appearance है Mr.
D. Mahapatra.
T. Mahapatra for the petitioner Mrs. S. Patnaik AGA for the state yes Miss Madam AGA it will be withdrawn the learned counsel for the petitioner files memo of date आज 10 तारीख था memo of date stating the following जे जहाँ लिखचंदी लिखि देबे on 9th February 2024 the following order was passed on being asked by the court the learned counsel submits that he has no instructions from the counsel of the petitioner who had handed him the brief the counsel from the lower court accordingly the petition stands withdrawn para the registry shall obtain instructions regarding the present status of trial and status of the petitioners status of the accused persons whether in custody oblique in bail the report be obtained to the district judge to be placed before this bench kebe on 19 हाँ 19 तारीख आम बेंच अच्छे नहीं ताले 12 रखले हम आज केते होची रे आज चल 12 नहीं पेटे ना ठीक अछि on 19/3/20 नहीं 19/3 नो भूल February or March identical. On 19/2/2025. Oblique when this bench sits next. Always be a professional, thorough professional.
Right.
You have to take care of your profession and everything. Don't go by, I mean, pass over.
Item 3.
Dune. Mr. D.K. Mahapatra for the D.K. Mahapatra for the petitioner. Yes, wants to withdraw. Mrs. S. Patnaik, AGA for the state. The learned counsel for the petitioner files a memo of date stating the following. Quote kar dena. On 6th of May 2024, the following order was passed. Today, when the matter is taken up, none appears for the informant oblique victim, though they were informed. Though efforts were made to inform them to the learned court in session as well as the learned counsel for the state. In view of the above, the petition stands dismissed as withdrawn. Memo डाले के लिए memo be taken on record. Memo is taken on record. Yes.
4.
I may be permitted to move this application on behalf of Mr. Das Mahapatra.
Mr. Biplab Mahanti.
Biplab Das.
I'm sorry, Biplab Das, B. Das on behalf of
Biplab Kumar Das.
B.K. Das on behalf of S. Das Mahapatra for the petitioner. Mrs. Patnaik, AGA for the state. Yes, Mr. Das.
The petitioner is in custody since 9th of June 2023 for commission of offence under section 37.
Entering. J.K.
Pardon.
Mahapatra. I was discussing this with Mr. J.K. Mahapatra. In POXO, read with 376 AB, I will not allow bail. Mrs. Patnaik, he has been acquitted. Mr. Asit Kumar Jena, A.K. Jena for the petitioner. Mrs. Suman Patnaik, AGA for the state. The learned counsel, it would debe tanku jeros kari copy. Learned counsel for the petitioner files memo of date indicating therein that the petitioner has been acquitted. In the meanwhile, after the completion of trial, rendering the petition infructuous, the petition stands dismissed accordingly. Registry shall obtain and record, obtain instruction from the judge court in session of the matter through the learned district judge regarding disposal of the matter, disposal of the trial, completion and completion of trial, not disposal, completion of trial. The instructions shall be placed on record, list on 19. Date apna? 19. The copy de debe AG. Yes, next please.
Item 6.
Yes.
Permitted to withdraw, my lord.
Yes, Lord Junior was discussing in the morning. I was discussing in the morning.
My lord.
You want to move the trial court?
Trial court, my lord. After exemption of some.
କେମିତି ଆପଣ ଏଥିରେ ପକ୍ଷରେ ତ ଟ୍ରାଏଲ କୋର୍ଟ once it is rejected by the High Court, you can't move.
Sir, I can. file it
ଆପଣ simply କରିପାରିବେ जो I was right ମୁଁ brief ଦେଖି ନଥିଲି ଚାର୍ଜସିଟ୍ ହେଲା ପରେ ଆପଣ ଆସିଛନ୍ତି ଏଇଟା.
My lord. After exemption of
There is no change in circumstances. ଆପଣ କେମିତି move କରିବେ ମୁଁ liberty ଦେଇଦେବି.
after exemption of some.
Just ତାପରେ ଭାବନ୍ତୁ that whole thing becomes I become a laughing stock. ପକ୍ସୋ ମ୍ୟାଟରରେ ମୁଁ ନିଜେ ରିଜେକ୍ଟ କରିକି ଲିବର୍ଟି ଦେବି ଟ୍ରାଏଲ କୋର୍ଟକୁ ଆପଣ କନସିଡର କରନ୍ତୁ ବୋଲି and it's a reasoned order. ଆପଣଙ୍କ ନାଁ ସାର୍?
Ajad Kishore Das, AK Das.
you have power. ସାର୍ ସାଇନ୍ କରିଛନ୍ତି ନା ଆପଣ
Yes,
କରିଛନ୍ତି?
sir, coach.
AK Das for the petitioner, Mrs. S. Patnaik AGA for the state. Learned, Learned counsel for the petitioner files memo of date signed by his leader, Mr. Panda, appearing for the petitioner, indicating the following. Since it is mentioned in the memo that liberty is to be granted to move the court below, the said liberty is. नहीं सेटा कौन लिखले नहीं ता पूर्व कौन लिखले stating the following quote कर देले पारा नहीं since no right ता quote करछि ना since तक करने the liberty to move the learned court below cannot be granted in view of the rejection of the petition for bail as by order dated 4/10/2023 in BL APL number 7815 of 2023, the petition, the prayer for bail was rejected. The order dated 4/10/2023 is quoted herein. The petition stands dismissed as withdrawn. Then para. Registry shall obtain up-to-date status of trial from the learned court in season of the matter. The matter shall be listed on केते 19/2/2025 आपण टिके गोटे काम करिवे से फेब्रुआरी टा एपुटू कर दियंतु टी कंफ्यूजन होछ मार्च आगे रहिलारु कंफ्यूजन होछ. Yes, that liberty cannot be granted in view of order dated 4/10/2023. I'm just, since you are not, none of you are preparing, I have to do this. Victim, this court is not inclined to grant bail to the petitioner at this stage. And still you are seeking liberty from me to move the learned trial court. Nothing to hide it. It's a POXO matter.
It's a POXO matter, no?
No. POXO matter is not supposed to be a good thing to you.
The only thing is that
I said, yes, Mr. Mishra, because you said something, you wanted to say something.
I
So
understand.
that is how. I passed the order that it will be Mr. तापर appearance election additional government advocate Mr. H.S. Mishra along with Mr. Balaram Naik for the informant.
No, I have appeared today. I am filing Mokladama today.
Along with the appearance lekhontu tapare sapara lekhontu the learned counsel Mr. Balaram Naik appearing for the informant submits that he has filed a detailed grievance petition before the Chief Justice, stating that this bench should not hear this matter.
Stating that the court has no confidence. In my grievance petition, it has not even mentioned that the matter will be heard by this Hon'Ble court. It has been mentioned that the client has no confidence upon this Hon'Ble court.
সেটা তো আপনার মো পারে পিটিশনটা ନାହିଁ ତେଣୁ କଣ କରାଯିବ ମୁଁ ତ କୋର୍ଟ କରିବାଟା ଠିକ ହବନି କଣ ଲେଖିଲେ
Because after bringing it to the notice of lordship,
just it is not defense petition before the Honorable Chief Justice. The bench should not hear the matters for the reasons stated in the petition. It is also submitted that the matter has been placed. Na kon koile? It has been placed before the acting Chief Justice. Na seটা
might have been, because otherwise the Registrar General would not have called him.
The matter is
Registrar
under
General-
the matter is before the registry. Hala?
The Registrar General called him.
The registry shall do the needful. List on 19/2/2025. Yes.
Item 10.
Yes. Ten pass over. 10 adjourn ହେଇଛି Mr. Memo ଦେଇଛନ୍ତି ନା ନାଇଁ ଖାଲି simply adjourn Mr. S.C. Tripathi S.C. Tripathi on behalf of M.K. Ponda for the petitioner. कौन लिखी The learned counsel for the petitioner seeks accommodation as prayed for the matter stands adjourned with liberty to mention before the assigned bench.
11.
Mr. B. Lenka, memo ଦେଇଛନ୍ତି ଦିଅନ୍ତୁ. Mr. B. Lenka on behalf of B. Lenka for the petitioner, Mrs. S. Patnaik, AGA for the state. The learned counsel for the petitioner files memo of date indicating the following. Para likhantu, in view of the memo, the petition stands disposed of as withdrawn. Not a copy करके दे दें. Yes, next.
13.
May I please, Your Lordship?
Yes,
In item 13, the order under annexure 4 is under challenge, madam.
yes.
It is order dated.
Mr. S.S. Bhuyan for the petitioner. 13, Mr. Sanjeev Swami, AGA for the state. Yes.
Order wide, page 55, my lord, is under challenge. Wherein the settlement appeal has been dropped by
Yes.
passing an non.
You are referring to which page, Mr. Bhuyan?
page 55, my lord.
55. Yes.
It has been dropped by passing an non-reasoned order. Whereas, on the other hand, if I may be permitted to at least give a gist of the fact of the matter, my lord, there was.
Sir, continue.
The gist fact of the matter is that, my lord, Sabik plot number
Yeah,
720.
how you are agreed by which portion of the impugned order you are saying?
That impugned order, my
This
lord.
is not appellable. This order is not appellable.
This order is
It's not appellable. So by which part of the order you are agreed?
It's
Or what is the
It's an order passed in 4 or 5 lines, wherein my appeal, the petitioner's appeal case has been dropped, stating that similar that it
so
is.
take notice.
Yes, ma'am.
You have made your point. The hard learned counsel for the petitioner. Is submitted by the learned counsel for the petitioner that the appeal case number 137 of 2000. So it is submitted by the learned counsel for the petitioner that the petitioner is agreed by the order passed by the settlement officer, Kotak Puri Major Settlement, Puri Wing, into bracket OP2.
No, my lord, it's OP3, additional sub-collector Puri.
Just a second. But you have not written the designation. Look at the order sheet.
My lord, the order sheet, he sign korche.
Yes, settlement. Upon dekho to order sheet of first page. Settlement officer, Kotak Puri Major Settlement, Puri Wing. He acts in complete different capacity.
Okay.
You should have, you can correct it also right now. You want additional sub-collector, Puri.
Puri.
Come.
Additional sub-collector is of the settlement officer.
So that you have to write.
Yes, my lord.
Because the statute confers that authority. The learned counsel for the petitioner submits, opening sentence submits that he wants a necessary correction in the cost title of the petition, wherein though additional sub-collector Puri has been mentioned, the said officer being authorized to act as settlement officer, Kotak Puri Major Settlement, Puri Wing, has not been mentioned. Prayer is allowed. The petitioner is granted leave. The learned counsel is granted leave to carry out the correction in the cost title. To be countersigned by the court master. File kadchandi. Call likhlo. Kadantu. Lekhuntu. Na tapar lekhuntu. It is submitted jota. Order dated so and so. Passed by the settlement officer. Passed by the additional sub-collector.
Yes, my lord.
Additional sub-collector, settlement officer, Kotak Puri Major Settlement, Puri Wing, in appeal case number 137 of 2016, initiated under section U/S dot 22 into bracket 2 into bracket small a of the Orissa Survey Settlement Act, 1958. It is submitted that subparakar lekhantu, a bare perusal of the order would indicate that the order only is of one paragraph containing few lines without delving into the facts of the case or the propositions of law. And observing that the case is dropped, the appeal is dropped. The appeal case is dropped kar diyo. So order dated लिखले 17/3/22 ହେଲା. Issue notice indicating that the matter is likely to be disposed of at the stage of admission. The lauded AGA, upon advance copy served, appears on behalf of the opposite parties 1, 2, and 3. Issue notice to opposite parties 4 to 10 by registered post / speed post with AD. Requisites for issuance of notice to the opposite parties 5 to 10 shall be filed within
3 days, ma'am.
Within 3 working days. Mr. Swai, you require extra copies.
Yes,
let 3 extra copies be served on the learned AGA. Para. List immediately after service return. Liberty to mention for listing before the assigned bench.
Much obliged. Well, my lord, I have also filed an IA
Yes.
for no
in
for no coercive
No,
action.
difficult, but because can you see the order itself?
Mhm.
The order itself says that the settlement officer in appeal case number 390/09, the suit property has been recorded in Anavadi Khata. If any order is passed.
But Mr. Mahanti, kindly look at 55.
55
55.
page.
That
Yes,
is the order.
I'm reading page 55.
55.
Yes.
Yes.
The case record is put up today.
Hmm.
The learned advocate for the petitioner is present.
Hmm.
Gone through the case record.
Kindly stop there.
Yes.
Yes.
Yes, gone through the case record thoroughly.
Kindly,
Peruse
yes.
report and Amin report.
Yes.
Then
Say,
it is important.
Mr.
It is law
Mahanti,
that
I'm sorry, I'm so sorry. Mr. Swai, if he perused the Paravage report and Amin report,
yes.
what prevented it from giving the details?
Then thereafter.
There is no reasoning.
That next line is important.
Yes.
Next line is it is learned that
It is
as
learned.
per
So
orders of the settlement officer.
Mr. Swai, kindly be so slow for that reason I'm telling.
Yes.
How a judicial, quasi-judicial authority will say that it is learned that without disclosing
Without disclosing.
anything. He doesn't disclose anything. Neither he discusses the report.
This land has already been settled in.
Correct, sir. Correct.
So,
But
it is no
when
more
he
available.
says that peruse the Paravage report and Amin report, he
Yes.
doesn't discuss anything.
No,
Those are the
next line.
those
next
are
line
the
is-
kindly. I have read the next line, but
Yes.
you are not answering. You are simply saying next line, next line.
Yes.
I don't know what is happening.
My lord.
He says peruse the Paravage report and Amin report,
Yes.
but he is the authority who has to discuss that report and pass findings, give his findings.
Yes.
He has not given findings.
Finding is that.
Please, then you answer that.
Yes, I'm answering.
No, the next line I'll go.
Yes.
But has he discussed? My
That-
question
that
is very
one-
simple.
That one line is the discussion.
No,
Yes.
that cannot be. I'm recording your submission then. Yes, please carry on now. Yes.
The next line is, it is learned that as per orders of the settlement officer in appeal case number 390/09, the suit property has been recorded in Anavadi Khata.
Yes.
If he has got any grievance with regard to the suit property recording in Anavadi Khata, it is open for him to challenge. Nor that the very same settlement
You
officer.
see, Mr. Swai, it is good that you are adding those whatever you have said, you are only adding to it.
Yes.
You are only adding to it. Or I'm wrong.
Yes, only that is the order.
So I have to record IA 16841 of 2024. Flag A. Had the learned counsel for the petitioner. The learned counsel for the petitioner makes his submissions as above. And 6 for interim prayer. For no further action to be taken. Upon interim prayer, कहले author?
No coercive action to be
No
taken.
coercive action to be taken. The learned AG in response submits that you want to that it is learned to that as per orders of the settlement officer that is your submission.
Yes, that has already
And
been.
perusal.
Yes.
The learned counsel for the AG, upon being asked by the court that the order is only one paragraph containing about 10 lines,
Yes.
justifies the order that the order is sufficient, the reasons have been disclosed, therefore no interim order be passed.
Very long back in 2009.
It is submitted that the officer passing the order has stated, quote कर देवे, peruse Paravage report and Amin report. It is learned that as per orders of the settlement officer in appeal case number 390 of 09, पर देखी जहाँ से reproduce कर देवे, faithfully reproduce it. The suit property has been recorded in Anavadi Khata. In the aforesaid premises, as the suit plot has already been disposed of on merit by the settlement officer, the present appeal cannot be heard again. Hence, it is rejected. Court ends. Para. On perusal of the order and considering the submissions of the AGA, it is apparent that the learned additional
additional sub
नहीं
collector.
नहीं सी जो सेटलमेंट डेजिग्नेशन दा कौन सब कलेक्टर का से पावर नहीं the settlement officer Kotak the additional sub collector com settlement officer Kotak Puri major settlement Puri wing is functioning as a Service Settlement Act. It is functioning as an authority notified under the Service Settlement Act and undertook the proceeding under section 20. The proceeding was undertaken under section 22(2) into bracket small a of the OSS Act. Bhai achi? Achi. Leon kadam, settlement kadam. The learned authority doesn't even refer to the khata number, plot number, description, map to arrive at the conclusion, much less give any factual finding. Apart from referring to the appeal case number 390 of 09, the learned authority has not discussed any of, has not indicated any finding to arrive at his conclusion to drop the case. Though the matter involves substantial right of a individual pertaining to property, the authority has indicated that he has perused perused Parawai's report and Amin report potents, but still does not refer to any reasoning or any finding of the Parawai's report and Amin report. In view of such gross irregularity, this court has no other option than to pass interim orders that no further action shall be taken pursuant to the order dated 17/3/2022 passed by the authority. List after SR is back. Liberty to mention before the assigned for listing before the assigned bench. This liberty is for you also, Mr. Swain, because you can always mention, because it's for the both. It's not for no no further action interim order. नहीं ता पूर्व लिखे सर्वे interim order जोड़ी सरला should insert करंतु the parties shall maintain status quo as on date regarding possession and ownership of the property. Mr. Swain, the best option you could have is that today this matter should have been remanded back, because Article 300A, Gordon Das Vanji, because what you did, you started supplementing the reasons.
That is
you see, even just you start, because I have the advantage of scrolling it. When he started submitting, actually I was looking whether he has referred anywhere in his order sheet. Then what is there in the events, that would have helped him. Because the proceeding starts on 31/12/2016. It ends in 22 years. 6 years. On not a single date he has referred to any fact or anything or any map or any description regarding the Amin report or the report. This cannot be. This will not withstand judicial scrutiny.
More submission there is very suit property that has already been decided in another case long back in 2009.
Yes, Mr. Swain, you don't have to. You may think that I am unable to follow. But for that, the minimum he could have done, refer to the facts and statement in that case, refer to the map, the report, and simply dismissed it. and that would have made it impossible for him to challenge, because this court is not sitting in appeal. You see, who in the whole process, what has happened? A order is passed referring to another appeal, 390 of 9, that doesn't refer even, he doesn't bother even that what is the plot number, what is the khata number, what is the publication date of the ROR.
ସେ shortcut ରେ ତାକୁ ଲେଖି ଦେଇଛନ୍ତି
No,
suit land
shortcut is no code. That is the difficulty.
elaborately
You see, suppose now I dismiss his writ petition. The first ground will be that he challenge that this court doesn't. I do not also make the same issue. Even I cannot decipher what is the plot number, khata number.
ସେଟା ଲେଖିଥିଲେ
Otherwise, no, Mr. Swai, ଆପଣ ତ ସେବେଠୁ ନହେଲେ ମୋତେ କହିପାରିଥାନ୍ତେ ଯେ the khata number, plot number is 399 and this plot are same. The record of the publication of the OSS map or ROR is same. You would have supplemented, then he has no case. Because I am not a corrective forum. And just read the orders passed for the last 6 years. Nothing, no reference.
Rather, what
If I quote Gordhan Das Bhanji, then I have to allow this writ petition. I am not quoting today. Mohinder Singh Gill and Gordhan Das Bhanji, they say about the administrative order, not quasi-judicial order, 300A. That you can't supplement. He might, you see, your submission that he might have passed a correct order is fully taken. I believe you more than him, because you will say something or the officer will say something in a responsibility. But he doesn't refer to anything. Not even a semblance of. Not only that, he has to mention that how he has come to a finding that both the properties are identical, the same property. That finding is not there. But anyway.
Rather, my lord, what he has done is in Annexure 3.
Kindly speak to the microphone. Since we have spent time, so you also say something. Because at times we plan to, you start the day with a meeting.
My lord.
At 11. After hectic last few days. So I had a meeting at 11 actually. So that is how you try to catch up with time. Yes, please. Please don't get disheartened.
No, my lord. What he has done is by Annexure 3, he has recorded the name of another purchaser on the similar footing who has purchased the land out of the same SABIC plot from my vendor. He has recorded his.
Check up all those things, factual.
Whatever I have felt or observed is absolutely correct now, because I do not know those facts. So that is another problem. You cannot, or me as a court cannot, seeing the order, see any khata plot, anything, any reference when the map is published. That he's saying now. Maybe encouraged by our discussion, but that has happened.
Let opposite parties appear. I will check up.
All these things actually you should only thing is private opposite party. Only at your level you should close these things. That he has to give those reasons, and he doesn't say that it is to be decided in his favor. Then that is a difficulty. He may reject it, no problem. Mr. Rautre may be aware. These kind of petitions in prior to 56 this act was before the sub-judge. So these were actually judicial proceedings. 62 पूर्वरु एटा थिला सेठी शूट रे होतला. Yes, next please.
14.
Yes, Mr. Behra.
On behalf of Mr. Behra, let it come next week.
भगवान भी adjournment नेबे केमति होबो? आपन ना?
SK Naik.
Mr. SK Naik on behalf of Mr. Bhagavan Behra for the petitioner, Mr. Sanjeev Sai AGA for the state, London Council for the petitioner seeks accommodation. आज prayed for. List केबे चाहुचंती? भगवान केबे चाहुचंती? भगवान जेबे चाहे हबो आगे कोन आपण एते समय नोचंती?
20 or 21.
अच्छा list after আজি केते हला?
10.
List after 2 weeks. Liberty to mention for listing before the assigned bench.
15.
Mr. Panigrahi.
Your lordship, my lord.
अरे आपण केमती पळे आसले? Nice to see you. आपण पुरी रहबा कथा.
Filing बेलको आसुची बजे.
Filing बेलको आछन. Good.
Submission, my lord. It recognized the Annexure 1, that is the not final ROR, published illegally in the name of the general administration. Because, my lord, by the annexure to the suit property stands recorded in the name of M.S.Sahoo.
You wanted to amend the petition. You said on the last occasion that you need to obtain instruction.
My lord,
Suppose, Mr. Panigrai, if you want to rely on those instructions, then bring it by affidavit,
my lord.
because they have to be given a chance.
Okay.
Na argument koribe without those.
I shall have to file the death certificate of my wife.
Happy on document upon rely kare, that is immaterial.
Suit
You may rely on any document, but please bring it on record. Mr. Tilochan Panigrai for the petitioner, Mr. Sanjeev Swahi, AGA for the state. Yes, Mr. Das, you were on the last occasion, you were there. So I'm granting that liberty. Mr. Swahi, I'm sorry, Mr. Swahi.
No.
कौन लिख ले? Appearance लिखो तो Mr. Tilochan Panigrai, Mr. Sanjeev Swahi, AGA for the state. Learned counsel for the petitioner refers to the earlier order dated 29th January 2025, submits that he has obtained the necessary instruction and may be granted further accommodation to bring on record in the form of an affidavit. Bring on record the instruction supported by affidavit. So, yes. List after 2 weeks.
Next week.
List on 19. Yes.
16.
Mr. B. Lenka for the petitioner. Mr. Sanjeev Swahi, AGA for the state. The learned counsel for the petitioner filed a memo of date signed by the lead counsel, Mr. G.P. Samal. Accordingly, the petition stands withdrawn. Copy करके दे देवे स्टेट को दे दे yes, if the petition stands disposed of as withdrawn, sentence the complete hearing, disposed of as withdrawn. Yes.
17.
Yes, please.
Order of dismissal of a bank officer, appeal it has been confirmed. And the ground on which I have challenged that the document which was also relied upon in the charge.
Mr. Sekhar, just kindly adjust the microphone.
And the bank officer who faced the disciplinary proceeding and ultimately was dismissed from service, in appeal it has been confirmed. That has been challenged. The ground of challenge, one of the ground of challenge is that the same allegations made against another officer of the bank, he has been demoted, whereas the petition has been dismissed from service. One. And second is there is a violation of principle of natural justice because the charges, the documents on the basis of which
it is same charges or similar charges?
Common, same.
Same charges.
Yes.
The submission is same charges. Yes, please.
He the petitioner is the chief manager. He is the person who has moved the file and everything. That is, and there is no allegation.
No, since it's a case of dismissal, notice has to be issued. Suppose, Mr. Rautray Senior Counsel, Buddhadev B. Rautray Senior Counsel, instructed by Mr. S. Sekhar, Shakti Sekhar for the petitioner. Hard letter Senior Counsel for the petitioner. The petitioner is the petitioner inter alia challenges the order dated 2/9/2021 passed by the appellate authority into bracket OP number 2 confirming the order dated 31/3/2020 passed by the OP number 3, disciplinary authority, imposing the major punishment of dismissal on the petitioner who was working as a chief manager. Sir, outright is chief manager.
Chief manager.
Chief manager
Of Union Bank of India.
under the establishment of the opposite party. In the establishment
Yes.
of the opposite parties. The Learned Senior Counsel submits that petitioner was imposed with the punishment of dismissal, though person similarly situated has been imposed with a lesser punishment. It is submitted that while imposing the punishment, there has been violation of the principles of natural justice and the due process has not been followed. Issue notice along with the issue notice on the petition as well as the application file karna because it's dismissal. So the कौन लिखले issue notice to the opposite parties by registered post with oblique speed post with AD. Requisites for issuance of notice shall be filed within
3 days.
3 working days. The opposite parties shall have the liberty to file their response on appearance. List after SR. Liberty to mention for listing before the assigned bench.
18.
Mr. B dot Acharya for the petitioner. Mr. Sanjeev Swang AGA for the state. The Learned Counsel for the petitioner seeks accommodation as prayed for. List after 2 weeks.
Next week.
List next week. Liberty to mention for listing before the assigned bench.
19.
19, in view of Northamratha case, I have filed a miscase before the SO, but it did not accept the same.
Sorry, in view of not?
Northamratha case.
Sorry, Subilani.
Northamratha case.
Norottomaratha case. Achha.
It is annexure 3.
But Norottomaratha jo order ta thila seta. Norottomaratha has been challenged.
Challenged on remand.
By Supreme Court.
Remand. After remand, the coordinate bench pass an order. After remand.
Coordinate bench mane ei bench ta no. Ne division bench re gote matter achi.
Seta jo mane OGLS re jauchan division.
Ne. Apanko OGLS ro hochi division bench. Our order is before the single bench.
Survey settlement.
So survey settlement is before the single bench. So now the problem arises, if you go look at the Supreme Court's order, they have not taken the aspect note of that aspect.
Liable.
Because single judge's order is applicable before the Supreme Court, not before the writ appeal.
No.
Division bench order, because the Supreme Court has taken exception that all these matters have to be remanded because all the petitioners have been treated together in one manner. But the single judge has not done that. The Norottomaratha order ta dekhele?
Annexure 3.
Supreme Court order ta?
No, Supreme Court order ta na.
Seta dekhantu. Seta no dekhile kon karibe?
Seta rakhini pakha.
Bartana apan chahunchandi kono?
Simple direction to accept and according to law.
Like Supreme Court ta dekhila pare na. It is a coincidence ki just in the division bench I heard this matter. So that is how I became aware of this situation. The Supreme Court doesn't distinguish between the different orders. Ebe achi Norottomaratha apana pakhare. Dekhantu. Have you seen Norottomaratha order by the SLP order? Ebe achi?
Ebe nahi.
Tale. The learned counsel for the petitioner seeks accommodation to obtain instruction as prayed and advance arguments as prayed for. List after a week. Kebe chahunchନ୍ତି?
Next.
List next week. Liberty to mention for listing before the assigned bench. Yes.
20,
Sorry, ଆପଣଙ୍କର ନାଁଟା ହଉଛି ମିଷ୍ଟର
Subhendu Kumar Naik.
SK Naik. SK Naik. Subhendu Kumar Naik. SK Naik. Yes.
item 20,
Mr. SK Nanda for the petitioner.
Minutes.
Yes.
The petitioner was a chief manager in the Indian Bank who has been put to disciplinary inquiry and has been lighted by final order dated 33/2024. He has been removed from service, and the appeal has also been allowed and dated. The appeal has confirmed the order on dated 11/7/2024. The petitioner
Appellate authority has confirmed.
Appellate authority confirmed that order. Well, see, there was initially one charge sheet was filed. Then the inquiry started. After the preliminary inquiry, then that charge sheet was withdrawn. Then again, without only administrative grounds. Again, another charge sheet, similar charges, only in charge number 12 and 13, some additional charges were given. And the entire...
So that is barred by the staff rules.
There is no
Withdrawal of a charge sheet before.
There is no such that is second charge sheet can be filed. The appeal rules.
There is no such bar according to you.
No such bar, and then
And the other aspect is that did they proceed on the first charge sheet?
yes, after preliminary inquiry, after preliminary inquiry, that was withdrawn.
Oh, acha.
Then
Yes.
second charge sheet.
Yes, that's a
Similar
valid
charges.
point. That's a valid point. Yes.
This is similar charges with some additional charges.
After preliminary inquiry,
It was withdrawn.
and you were given a show cause.
Yes, yes.
You filed your show cause.
Yes, yes. The second charge sheet was filed, and again I said.
So after filing of your show cause, they withdrew that charge sheet.
Yes, after I filed show cause, the inquiry initiated, inquiry officer was fixed.
Apanko first was the first show cause given to you that why disciplinary proceedings shall not be initiated.
Yes, I participated.
So you gave your reply.
Yes.
So after you gave your reply, then the charge was withdrawn.
No, a disciplinary officer was appointed, inquiry continued, preliminary inquiry was there. Then after
No,
preliminary.
there is no concept of preliminary inquiry at that stage. Preliminary inquiry is before the initiation of the departmental proceeding. If
No,
they are
here-
satisfied, suppose you admit your delinquency, then it will not. There will be no DP. You do not admit your DP delinquency, then there will be a DP. If they do not accept your show cause. But here you are saying that the disciplinary proceeding was initiated and completed.
Not completed. After preliminary hearing was done, not inquiry, preliminary hearing was there. After preliminary, during regular hearing, it was withdrawn.
Acha. Then what is the next point?
Then second charge sheet.
Then what? You took these grounds in the appeal also.
I took grounds in this appeal also. And apart from that, in the second charge, entire proceeding was completed in a single day. No witnesses were brought. And that I was.
No, you have already argued the best point. That's the best part of it. Always argue the best point. So, because that is very difficult to prove. Inadequacy of opportunity to completing the proceeding is very, very difficult.
Various regulations were not
Right.
followed.
Mr. SK Nanda Lekhile. The petition, hard learned counsel for the petitioner. The petitioner challenges the order passed by the disciplinary. ପୂର୍ବରୁ ଗୋଟେ କରିଛନ୍ତି ମିଷ୍ଟର ବୁଦ୍ଧଦେବ ରାଉତରାୟଙ୍କର ଆପଣ କରିଥିଲେ ତାହେଲେ ସେଟା ଦେଖିକି ୱେବସାଇଟ୍ କରିଦେବେ ଏଇଟା ବି
17 ନମ୍ବରଟା ଥିଲା
ହଁ it is submitted by the challenge ଟା ସରିଲା ତାପରେ ଲେଖିବ it is submitted by the learned counsel for the petitioner that the procedure adopted to impose the punishment of dismissal major punishment of dismissal is without authority of law, violative of the principles of natural justice, and the procedure adopted of withdrawing the charge sheet and filing another charge memo withdraw kar dele, withdrawing the charge memo and substituting by another memo after initiation of and continuation of the proceeding is alien to law.
And along with in the second inquiry also, he was not provided with adequate
Issue
opportunity.
notice. Rest is same. If how much time to file requisites?
3 days.
3 working days. Rest is same.
Obligement.
Yes. Yes. Next, please.
21,
It is by registered post and
Oblique. Registered post, oblique, speed post.
May I please, Your Lordship?
Yes, please. Mr.
Matter
Rao.
relates to non-payment of yield of the petitioner, my lord, for certain period, my lord.
ଟିକେ ଉପରକୁ କରିଦିଅନ୍ତୁ microphone ଟା.
My lord. Matter relates to sanction of EL, my lord.
ଆଚ୍ଛା.
Instead
Extraordinary
of
leave. Extraordinary leave.
No. That is earned leave,
Earned leave.
my lord.
Acha.
But they have sanctioned extraordinary leave, wrongly sanctioned. My prayer is it is earned leave for certain period, my lord. Petitioner.
Where is the impugned order, sir?
No,
ଆପଣ order କିଛି ଲେଖୁନାହାନ୍ତି ତ? So where is that?
it is page 11. This copy of the service book, my lord. It is not
No,
legible.
no. Are you impugning any order or you are seeking a prayer, mandamus?
Prayer.
Mr. Khirot Kumar Raut for the petitioner. Mr. Swai, you are there here.
Yes.
Mr. Sanjeev Swai for opposite parties 1, 2, 3 and 5. So Patra, you inform Mr. Sudhir Patra, standing counsel.
My lord.
Mr. Or you take notice to Principal Accountant General because he remains present, accepts copy.
I'll take notice. Okay. All right, I will serve.
ଆପଣ notice ନିଅନ୍ତୁ copy ବି serve କରିଦିଅନ୍ତୁ
ଆଜ୍ଞା.
because he is not there. ଯଦି ସେ ପରେ ଆସନ୍ତି ତାହେଲେ I can record.
My lord.
ସେ ଆସୁଥିଲେ କ'ଣ there is some difficulty maybe not there. ତାପରେ ଲେଖନ୍ତୁ the petitioner is agreed by non-sanction of earned leave and grant of extraordinary leave in state
My lord.
after his retirement.
My lord.
After his retirement from service, under the establishment of the opposite party number 1, 2, 3 and 4 कर दियो. Issue notice. The learned AGA upon advance copy served appears and waives notice on behalf of opposite parties 1, 2, 3 and 5. Let 3 extra copies be served on the learned AGA to enable him to obtain instruction and file counter if necessary. Issue notice to OP number 4 by registered post oblique speed post with AD. Requisites for issuance of notice within 3 working days.
No.
Within 3 working days. List after SR is back.
22,
22, my lord.
Liberty to mention for listing before the assignments कर लेके जाओ.
GPF amount of the petitioner has not been paid. The BDO Raigar, opposite party number 5, by the annexure 3 and 4, has written to the authorities to pay the amount, my lord. But till now it is not paid, my lord. Your lordship.
Same order कर देवे. The खाली लिखन्तु appearance लिखिले. Mr. Swai, you are there.
Yes.
Mr. Swai for so and so. The petitioner is had to learned counsel. तापर लिखन्तु the petitioner is acted by non-sanction and payment of GPF
My lord.
due to him. ता कौन आउ जने ना नहीं से केका लोको.
Ekal.
वो GPF टा अलगा करचंदी petition.
Aye.
After his retirement from service while working as
Working as assistant.
assistant executive engineer in the establishment of the opposite parties 1, 2, 3 and 5. Issue notice. Rest said. In these matters, Mr. Swai, instruction will be enough. If there is some official, in the process, he might have, at times they don't also understand that what is to be done and what is not to be done. It can be facilitated. You cooperate, Mr. Raut. Suppose they want something, some application or some certificate, you are not giving.
No,
That causes the delay.
I have given everything.
No, I'm not saying, I'm saying about in the office.
Obliged.
Yes.
So keeping it to 23 2
After 4 weeks, brother. Mr. Raut, how much? After 3 weeks. Mr. Swai, after 3 weeks.
I think notice has to go to OP number 4.
Yes, same order.
Same.
So after 4 weeks, could be.
4 weeks.
Least after 4 weeks, that's prayed for. Yes.
My lord, Mr. Vasudev Pujari will argue this matter. Kindly taken up 2 weeks after.
You are Mr. Sahoo.
My lord.
Mr. M.S.Sahoo for the petitioner, Mr. Sanjeev Swai AGA for the state. Learned counsel for the petitioner seeks accommodation on behalf of his senior. List after how much time, sir?
2 weeks after, my lord.
List after 2 weeks. Liberty to mention for listing before the assigned bench. Yes, next.
24.
Please, my lord, yeah.
Mr. Niranjan Ponda for the petitioner. Mr. Sanjeev Swai AGA for the state. Yes.
Release of my GPF and as well as the unutilized money. That is my prayer.
The petitioner.
He was an assistant engineer.
The hard-learned counsel for the petitioner. The petitioner is agreed by the non-sanction of his non-sanction and release of
GPF.
Unutilized leave and general provident fund amount after his retirement from service while working as
Assistant engineer.
Assistant engineer in the establishment of the opposite parties.
Yes.
In the establishment of the opposite parties.
Video Ganjam.
Video
Ganjam.
Acha, OP number 5.
Yes.
Number 5. Hard lecture issue notice to the opposite parties, learned AGA upon advance copy served, received notice on behalf of the opposite parties, appears and waives notice on behalf of opposite parties 1, 2, 3, 5, 2, 7. Jilla Parishad, you will not appear. Acha, tale 1, 2,
5, 6.
5 and 6. Issue notice along with this order to the opposite parties 3, 6 and 3 and 7. 3, 4 and 7. 3, 4 and 7 by registered post, speed post with AD. Requisites to be filed within
2 days.
Within 3 working days. Requisites for issuance of notice to be filed within 3 working days. List after 4 weeks. Liberty to mention for listing before the assigned bench. The list जो 4 weeks लिख लें तब पूर्व लेखन तो the learned AGA copy extra copy lecture थी. The learned AGA 4 weeks time to obtain instruction and file counter. As prayed for 4 weeks time granted to file counter, which shall be filed after serving copy thereof on the learned counsel for the petitioner. Petitioner shall have liberty to file rejoinder. Yes.
25.
Mr. S.C. Das, Subhash Chandra Das for the petitioner, Mr. Sanjeev Swai, AGA for the state. Yes.
Contempt application, my lord. My lordship had directed an order dated 17/8/23.
25.
My lord.
25 contempt asini. Bhul file asigi. Upon contempt kouchandi.
Contempt.
Number ta?
That is 3204.
25. A court re aji list heichi. Okay, pauni.
Nine, sir.
Nine to.
I'll find
Upon list dekhile.
3204 33. 33.
Sir, 33 again. Mr. Das, it is upon matter 33.
Man, sorry, man.
Yes, 25. Pass over. Tapare.
26.
Mr. G. Chaitanya, on behalf of B.B. Mohanty for the petitioner, Mr. Bimbisar Das, AGA for the state, Learned Counsel for the petitioner seeks accommodation. As prayed for.
Get notice done.
Again?
Since he is seeking employment from 2015.
आरंभରୁ mention କରିଦେଲେ ସେ କହିଲେ ଆମ senior ନାହାନ୍ତି. As prayed for, list after a week, liberty to mention for listing before the assigned bench.
27.
7, man.
Yes, please.
I am challenging the.
You are Mr. Jana Samanta?
Yes, ma'am.
Mr. T.K. Jana Samanta for the petitioner, Mr. Bimbisar Das, AGA for the state. Yes.
Page number 10, Annex 1, my lord.
Yes, please.
In this case, my lord, learner tribunal directed.
You are seeking compliance of the tribunal's order.
Yes, they have already complied, but 9% interest is still pending to be paid.
Tribunal direct करथिले कि?
Tribunal direct करथिले 9% per annum, para 7, my lord.
Then Mr. Das, then you have complied, he is saying.
I'll have to take instruction.
Yes.
First
Yeah,
time.
because there is nothing remains.
Another objection, my lord. An order is to be complied with by way of filing another.
My lord, I have filed an RTI application.
Contempt. No, original application converted to writ petition. Order passed in the writ petition will be complied with in another writ petition or a contempt. Even then, I'll take instruction about as to whether that 9% why it has not been paid.
Hey, should have failing which is the default order.
Yes,
Mr. Jana Samanta, can look at 13.
That's what I am saying, my lord.
So they are. It is not an order where it has been violated, you can say.
No, my lord, there is a delay of 5 years, my lord.
Kindly look at 6.
Para 6. Hence, in the result, NHA 2 and 4/A are request. The response are direct to allow second SCP to the applicant with effect from 30th January, so and so.
Yes.
Accordingly, fix his pay and disburse the area amount till the date of his superannuation on dated 30th April 2021, and also fix his pension and other retirement benefits accordingly.
Then read further.
Para 7, man.
Obviously, sir, more subuk stage re apan manuk assist karibi.
The entire exercise will be completed
and I have to listen
within
so
a
many
period of
things.
4 months from the date of receipt of a copy of this order. Failing which the applicant will be entitled for interest at the rate of 9% per annum on the area dues and the
Strictly speaking, this order says that if you fail, so now you should have come to the court after 4 months, either with a contempt or for implementation.
Yes, thereafter state.
So, apanakara this order is of
Annexed 2, my lord.
18/1/16.
Yes.
So after 10 years, how 9 years, how it is possible? 1 year is contempt.
Thereafter, kindly see Annexed 2. My lord challenged this case before at that time, my lord, the GA. Annexed 2, my lord.
अरे पेज टा कोंतु सर बड़गर बेले बेले पेज मिलुनी
1/4
and I have difficulty
14, my lord.
फिर मो ना रेकॉर्ड हिची MS Sahoo ना रेकॉर्ड हिची
My lord,
ताले I should not take this up
नाटा रेकॉर्ड ହେଇନି
ଆପଣ କୋର୍ଟ जो कहले मु देखिली I have marked that, so I was appearing in that court.
Yes. The order is passed 10th of July 2018, my lord. Dr. K.C. Raj.
तापर कौन हला? Yes, Mr. Jana Samanta.
Thereafter, they have complied.
They have complied after in 2020.
Yes.
When the writ petition was Justice Muralidhar's judgment.
Yes.
That was confirmed by the Supreme Court. Are you aware?
No,
this promotion whether amounting to this
RSU benefit.
ଆପଣ ଯୋଉଟା ନାହିଁ କି ସେଥିରେ
RSU benefits.
just ଆପଣ last page 17 ରେ last two lines ପଢନ୍ତୁ. Internal page ଟା ସେଟା order internal page 2.
17 minus.
The tribunal, considering the respective pleas of the parties, came to conclusion that the upgradation of OMS class 2 cadre to class 1 junior grade cannot be treated as promotion of the applicant to the higher grade.
Yes.
So this has been settled Bharat Sanchar Nigam. So our court, after following Bharat Sanchar Nigam, has pronounced judgment.
Justice Rabindranath judgment.
Sorry?
Supreme Court judgment has been followed in this case.
So that judgment came in 2021, November most likely. So till 2021 November, I think they have complied when?
Just limited period, my lord.
Just thereafter.
9% interest.
Date कोटी कहला अछि?
That is available at page 22.
22.
Yes, ma'am.
So that will indicate that
After that.
yes, 29 December.
Yes, after that judgment. So how
Thereafter, file a RTA application, my lord.
RTA application, this was, I mean, entangled in litigation till that date.
Annexure 4, my lord.
They say instruction nebe je, but I don't know.
instruction
See to कहले instruction nebe boli, but why you have not filed a contempt? They cannot sit over court orders, na? That's the first thing. Now, since you said I was appearing, I tried to recollect. Second matter, I was also appearing. Mr. B. Rautray, senior counsel, was for the appellant state, I was appearing, and Mr. Rautray was. So that judgment I could not mark because of elevation. Later on, I have read that judgment that they have given all the reasons. Upgradation doesn't amount to promotion. Bharat Sanchar Nigam. Call like the learned counsel for the petitioner submits that the order passed by the tribunal, the learned weighty circuit bench Berhampur. ମୁଁ ଠିକ କହୁଛି ତ ବହୁତ order ଅଛି ଭୁଲ ନ ହୁଏ.
OA 36B.
The order dated 15/1/2016.
January.
15 January 2016 has been complied with partly in as much as the benefit as directed in para 6 of the order has been granted. But the interest at the rate of 9% per annum on the arrear dues as directed by the tribunal for delay in payment has not been granted. The learned AG in response submits that he shall obtain instruction in the matter. How much time?
3 weeks time.
As spread for list after 3 weeks. Mr. Das and Mr. Jana Samanto, it is only a suggestion. I have been suggesting this. You accept a lump sum amount because you are not a daily wager. You are not a daily wager. You are getting a pay band 6 or 7 pay scale. You are given promotion. Here there is no denial. It was, involved in litigation, complete involvement in litigation. And coincidentally, if the litigation ended in November, they have given it in December.
So,
ଆପଣ 1.5 ଲକ୍ଷ ଟଙ୍କା ପାଉଥିଲେ, ଆପଣ ପାଇବା କଥା 1,55,000 ଟଙ୍କା. So how much you are deprived? And that 9%, the tribunal has said the government is liberty to recover such extra expense on account of interest from the authority. Which authority will be held responsible? High Court.
High Court, Supreme Court.
High Court, Supreme Court have to be held responsible. जी आज्ञा डेली वेज पाउछन्ती तांकर आपण पाइबेनी 20 टका सैलरी 20 टका डेली वेज आपण जानछन्ती कोड़े टका daily wage थिला 4 टका थिला ता आगुरु I mean I have seen
minimum daily wages.
minimum wages जे पाउचंती even a skilled wage भी जे पाउचंती 800 टका ताको आपण तो 1.5 लाख 2 लाख टका पाइबे. Those 9% will be paid from whose you, because tribunal is conscious of that.
Yeah.
Sir, it is taxpayers' money. That 9% is taxpayers' money. This was told by long back, almost 20 years back by Justice Naidu in one court. I was arguing for the petitioner. He said the same thing. ଆପଣ କଣ ସେଥିପାଇଁ ଅନେକ ବସିଥିଲେ 5% 10% ପାଇବେ ସୁଧ ବୋଲି.
Instructional client,
No, so why I say this? I am only suggestion is that you accept a lump sum amount. Suppose you say they will give you 10,000 or 5,000. That is a better way. Because they have not challenged that part, they maybe, I don't know, they have challenged High Court modify that's a different thing. Se part modify dekhele. But se jo litigation ta chalila, ta kete page re dekhutile High Court order ta last page ta 23.
17 to 23. 17 to 23 litigation. 6 years.
But usually I pray for extension of the order. If I was arguing that matter, I would have prayed that some further time may be granted. Yes, instruction Anantu. I don't know whether it will be workable. But if you see that there has been actual delay and the court order has not been complied and partly complied, so that way, or they may explain also that since till
your lordship's advice, if he accepts, he will be benefited. With my little experience, I am saying this case cannot be allowed because contempt, deliberate violation. Where comes the question of deliberate violation when the case is pending before the Hon'Ble High Court and Supreme Court? Deliberate what cannot be explained.
Sijut 21 ne bhi delay hai nahi. Anyway, you take your chance.
Yes.
Yes.
28.
At times I'm not hesitant to share my thought process, trusting all of you, not taking any view. No view is taken by this. Either way. Yes, Mr. Guru.
Please, my prayer is that I have a land within the urban area of Dhenkanal municipality, and I pray that the section 22 of OLR Act is not applicable for sale of that property. Already this Honorable Court has rendered a judgment.
So, Mr. You take instruction.
So I have already given.
Now he has given me this copy.
Mr. K. Guru for the petitioner. You want disposal?
Yes, my lord.
No, more high disposal darkar nahi. Low disposal is good enough. I was not setting target when if I would have set a target, then like the things would have been different for me. Whether I would have accepted that or not, that's a different thing. No, he's now 70 years. He's now 70 years. There's no point in disposing it of. He'll struggle for another some years.
This Honorable Court has already rendered a judgment.
Yes. Let him take. Mr. Das, you are conceding.
Sorry,
you are conceding. If he concedes, then no problem.
Since my learned friend gave it just now, I have
you obtain specific instruction of your clients, the state on that.
Yes, my lord.
Inapplicability of OLR Act to a municipal is a factual aspect.
Yes.
There can't be any dispute also. No. The fringe area, bordering area, that you take that instruction. And once you that, then let him get the order.
Yes, ma'am.
Mr. K. Guru for the petitioner, Mr. Bimbisar Das AGA for the state. It is submitted by the learned counsel for the petitioner. Hard learned counsel for the petitioner. It is submitted that the petitioner impugned order ta kota challenge korchonti?
Impugned order kichi nahi. Just
seeking a direction. The petitioner seeks a direction that the section 22 of the OLR Act is not applicable to the petitioner's land. As petitioner's land, as I described in the record of right enclosed to the writ petition marked as Annexure 1. The learned counsel for the petitioner relies on the decision of an order, not judgment. Order dated?
Order dated 11/12/2024.
11/12/2024, passed by a coordinate bench.
In WPC number
In WPC number-
30871 of 24.
Please repeat WPC number
30871
30871 of 2024, holding that Welfare Act is not applicable to the municipal area,
Yes, ma'am.
to the municipal area in the Dhenkanal Township.
Dhenkanal town.
The Dhenkanal Township. Copy of the order is handed over to the learned AGA to enable him to obtain instruction. The learned AGA seeks how much time?
2 weeks time. Sufficient.
6
1 week time will be sufficient.
1 week time to obtain instruction. 2 week time to 2 weeks time to obtain instruction. List on 26টা ছুটি ଅଛି पण 19 ରେ ଆଣନ୍ତୁ 1 week କରି ଦିଅନ୍ତୁ 19 ରେ ଆଣନ୍ତୁ ଦେଖିବା ଯଦି ଆସିଗଲା ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଖ
19
ହଁ 1 week time list on 19 2/20/25 as prayed for. Yes, liberty to mention for listing ଦେଇ ଦିଅନ୍ତୁ
29.
after recess we will resume. Any mentioning?
After item 2, 6 and 11.
2, 6 and 11. Yes, Pastor what I can do 2, 6, 11.
Pass over item 2.
टी बार करथिबे you have mentioned 2, 6 and 11. अच्छा pass over item 2 call next pass over 6 डाकंतु
Item 7.
sorry serially डाकी जानतु
7.
हाँ 7 2 7
7. 11. 25.
ଆପଣଙ୍କର 25 ଯାଏ ଅଛି ଠିକ ଅଛି ସେଟ ରହି ଯାଉ ଦେଖିଲେ ଆମ ନମ୍ବର ନୋଟ କଲେ 2 7 11 25 none appears for the petitioner though the matter is called twice over. Up to 25 all you are there. अच्छा ଆପଣଙ୍କର କୋଟା କୋନ୍ତୁ
6, 7, 2, 7 and 11.
2 7 11 Mrs. Patnaik AGA 25 Mr. Sanjeev Swai AGA appearance ठीक लिखिबे none appears for the petitioner though the matter is called twice over once when it reached and thereafter at 1:15 p.m. to grant further opportunity the matter stands adjourned. After 2 weeks liberty to mention for listing before the assigned bench. Same order टा सबुती reproduce करते खाली appearance टा बदलुची. Yes mention कौन करथिले
Item 30 I am seeking for
30 you are Mr. Naik GR Naik for the petitioner 30 Mr. Das.
Yes,
Mr. Bimbisar Das AGA for the state. Accommodation is sought for by the learned counsel for the petitioner. How much time, sir? As prayed for, list after 2 weeks. List liberty to mention for listing before the assigned bench. This is not the assigned bench. This is today is a break bench. There is some confusion. Mr. Chuli, please.
May I pardon to mention?
Mention jaldi sarantu sir. Kote kudi hala.
My item number 49.
कौन
I pray for adjournment.
Mr. Purushottam, Dr. Chuli, Dr. P. Chuli for the you pronounce it Chuli, not Chuli. Chuli. Dr. P. Chuli for the petitioner 49 रे किए अच्छा Miss A. Das you have recovered you are not appearing take care of your health
not completely
you should Miss Aishwarya Das ASC for the state learned counsel for the petitioner 6 accommodation as prayed for how much time
Tomorrow.
Tomorrow not possible it has to list next week
Mal.
liberty to mention for listing before the assigned bench
Hopeless.
Item 40 my lord.
tomorrow अच्छा आज कितने तारीख है 10 it can be listed on 12th
Mal.
you want before this bench
I was on arguing.
ना ना एटा लिस्ट कोठी चाहुचंदी माने 12 असाइन बेंच रे आसीबो ना 12 तारिख ए बेंच रे आसीबो
Assignment.
Liberty to mention for listing before the assigned bench. Yes, next.
Item 40, my lord, next week, my lord.
20.
Yes, 40, my lord, item 40.
40.
Yes, my lord. WPC 23.
बोलते कानरे पानी पशिला है कोण. I'm scared of that. मत क्या सुबुनी?
WPC 23.
40 हला. Yes, Mr. Swayam Prabhu Jenna for the petitioner 40 rekhi. Ms. Aishwarya Das AC for the state. How much time?
Next week, my lord.
List after a week. List next week. कर दियंतु. 40 रे next week कर दियंतु. Liberty to mention for listing before the assigned bench.
Lordship, item 42, Lordship.
Yes, please.
Item 42, Lordship, please.
Quick. हाँ.
Lordship.
ना कौन तो आगा.
Lambit Senapati.
Mr. Labit Senapati. L Senapati. अच्छा, you are the petitioner.
Yes,
Mr. L. Senapati for the petitioner. Opposite party blank. Anyone appearing, Mr.
42.
It's 42 millets. I have instructions.
Mr. L.K. Maharana. Yes, I was thinking that where are you?
Millets.
Mr. L.K. Maharana for the opposite party. The opposite party. आप लोगों ने वकालतनामा दिले नहीं?
No, millets. I have instruction to appear. I'll file it.
अच्छा. So then the opposite party blank. चला. Lord L.K. Maharana appears on behalf of the opposite party, submits that he has instructions to appear and shall file his wakalatnama. How much time?
So within 3 days, I'll file it.
A big minute.
How much time?
Within 3 days, I'll file.
Within a week.
Millets.
Mr. Senapati, Learned Counsel for the petitioner, 1 week accommodation.
Yes, Lordship.
List after a week.
Yes, Lordship.
Mention for listing before the assigned bench.
Millets, may I request my learned friend for a copy of the petition?
Yes, Lordship. I will serve.
That you.
I will.
Since you are not, you have not filed wakalatnama.
I will. I'll take that.
You have to take everything into consideration.
My lord, oblige.
Serve a copy. Keep his request. He will anyhow appear.
My lord, oblige.
Much obliged.
Thank you.
Oblige.
I took 47 Arjun. 47.
Sorry, kindly speak to the microphone.
Item 47.
What do you want, sir?
GK number on behalf of GK now.
Apan ko naata, sir?
RN Bari.
RN Das.
RN Bari.
RN Barik.
Rabindranath Bari.
Rabindranath Barik. Mr. Rabindranath Barik on behalf of GK Nanda, on behalf of the petitioner, Ms. Aishwarya Das, additional standing counsel on behalf of the state. 47, Ms. Das. He seeks adjournment. The learned counsel for the petitioner seeks adjournment. Kete dino?
Any date.
Any date to hyperioni. List after a week as prayed for liberty to mention for listing before the assigned bench. This is a break bench.
Item
Yes.
29.
Yes.
May I please, boss?
You are Mr. Sahoo.
Yes,
SK Sahoo.
Yes,
For the petitioner. Mr. Bimbisar Das, AGA for the state. Yes.
My lord, here the petitioners are challenging the order passed by the Additional Commissioner Consolidation and Settlement at Baleswar.
Have you made the proper party?
Pardon, Lordship.
Yes, you have made him a party. Additional Commissioner Settlement and Consolidation Bhadrak.
Yes,
but he must be having a dual charge.
Yes, my lord.
So you have to write that sub collector, additional commissioner.
The
Order is passed by the additional
by
commissioner.
the
So, no, this was just now discussed with, I was telling
Yes,
Mr.
ma'am.
Bhuya, I think. Just the previous matter of that there the additional commissioner was not a. No, the problem is that Mr. Sahoo,
My
suppose I am issuing notice now.
Yes, ma'am.
So we notice he will appear, that's the only advantage. But even he cannot, he has to send the letter or requisition to somebody where he will send.
Yes, I will do the correct.
So you have to mention the correct official address.
Yes, ma'am.
Suppose you mention Chief Secretary Odisha,
Yes, ma'am. I on.
then Banijya Kar Bhavan Kotak.
Yes, ma'am.
Will the notice be sufficient?
No.
It has to be Lok Sabha Bhavan Bhubaneswar.
Yes.
So that way there will he cannot send the letter also. At the opening sentence statement lekhantu sentence lekhantu. Hard learned counsel for the petitioner. The learned counsel seeks for leave to make a correction in the cost title of the petition. Sub collector तो ठीक तो ना सिटी आउ किए अछंती असिस्टेंट की डेप्यूटी सब कलेक्टर कौन अछंती तो से फिर सेटा गोटे भूल
नहीं सर ठीक है
लिखाई सब कलेक्टर कम
सर सब कलेक्टर
को ऑर्डर टा इम्प्यून ऑर्डर दिखांतु
इम्प्यून ऑर्डर इज एनेक्स 2 माय लॉर्ड पेज
हाँ।
16
हां सेटा तो एडिशनल कमिश्नर लिखा हबो
अगेन सेटा say order passed by the Bhadrak additional commissioner Bhadrak but initially the revision case was filed at Baleswar
सेटा बाइफर्केशन हे जिछ
again sir सेटा ये ट्रांसफर हे के आसी भद्रक रे सुना होछ
एटा अपेलेबल ऑर्डर नो
नो माइल this is 15B order or under the OSS act
एटा कैंप एट भद्रक ना नहीं ऑफिस एट माने भद्रक लिखा है पूरा
again Bhadrak I have given the address of the passing order passing
so let it be there so जो लिख रहे सेटा का नहीं सेटा काटी दियंतु The petitioner is agreed by the hard learned counsel for the petitioner. The petitioner is agreed by rejection of
revision case.
Rejection of his revision petition filed under Section 15 into bracket small b of the Odisha Survey Settlement Act, 1958. By order dated, देखा जाओ नहीं order टा?
Order dated
11 September
24.
11 September 2024, passed by the Additional Commissioner Settlement and Consolidation, Bhadrak. In revision settlement case number 527 of 491, 527 of 491 oblique 2019. देखिए कि लिखिए भूल भाल हबो नले पेज 16 देखिए लिखंतु हैला. Yes, what is your case, sir?
Here, my lord, the revision case was filed for correction of kisamo of land relating to one plot. That is 2335, my lord. That is my grievance in the revision petition. Lordship kindly comes to.
No, I don't. You carry on.
My lord.
I'm listening.
Yes.
You filed a revision application for correction of map, ROR or map.
No, my lord. Kisamo of land.
Kisam of a land. You have you have mentioned. You have mentioned. Yes.
Yes. That is the 2335.
Yes.
But the authority has decided as if I have filed the case for 2319. That is another plot that belongs to the petitioner, my lord. But I am limited to that plot, that 2335. It was the kisam of the land is road. I need the correction that it should be Sarada.
Acha.
That is my case. But the authority has decided as if I have prayed for the plot number 2319. And the case of the petitioner is supported by the RI who has conducted the field inquiry as well as verified all the current settlement record of
and the final publication of ROR when?
The final publication.
Date of final publication?
Final publication. There is a delay, my lord, that was condoned by the authority.
Acha, delay has been condoned.
Delay has been condoned.
Okay.
And the authority has decided what the authority has done.
Yes, I got your submission. The learned counsel for the hard learned counsel for the petitioner, it is submitted that the tapore jota upon likhle set up complete paragraph is the sub para likhantu. It is submitted that the order passed by the authority suffers from illegality and erroneous recording of fact, inasmuch as the kisam of land which was sought to be corrected, the order refers to another land. Acha, hal sabik problem achi?
No, sir.
Both you have mentioned hal khata?
Again.
Hal khata plot?
The CS khata, MS khata, and the Bay Bandobast khata.
Order, referring to the order, whether the authority mentioned the incorrect MS khata plot, or there is a mistake of khata plot.
No, my lord.
There also.
There is no mistake.
No mistake.
No mistake.
Hal sabik CSMS all are
considering the 2335 plot. He has considered 2319.
That is available at page 17.
17.
17.
Mhm.
Last, your lordship may come to the last person 1, 2, 3.
Hmm.
3 paragraphs have been numbered. Number 1.
Hmm.
In the plaint submitted by the petitioner, it is stated that the MS plot number 2319 and MS plot number 2335 are referred to in CS number so and so. But in the MS of the corresponding MS Khata number 1880, the land was recorded Bebandosti. What my learned friend was submitting, that in place of 2335, it has been wrongly reflected as 2319. But from this order, both the plots have been taken into consideration.
Initially, that was a one plot in CS Khata. In MS Khata, that plot was divided into 2 plots. One plot is correct in Kisam, but the another plot, that is the 2335, it was made as road. That is why I filed the revision case to correct that Kisam. But the authority has decided, which I have not sought for correction.
Your lordship may allow me to take instructions so that
The omnibus,
It has to be remanded again.
Yes, ma'am.
Smeller, your lordship can
This is not a fact-finding court.
Yes, correct.
Here, my case is supported by the RI, my lord. Your lordship kindly see the page 43, the RI report.
No, RI report
Was called for by the
but it is not binding on the authority.
Yes.
It is not binding.
My lord, here,
Authority, that was the
Yes, ma'am.
discussion Mr. Swami was arguing. He has to refer to the RI report just now. Actually, it's a coincidence.
Yes, ma'am.
He has to discuss it and give his finding.
Yes, my lord. All the documents are before the divisional authority, but he has not considered that.
The plot number of the land, next sentence, the plot number of the land of which Kisam was sought to be corrected in the proceeding has been wrongly mentioned. Private party ki ochandi?
No, my lord.
No one is affected.
No, my lord.
The issue notice, the learned AGA upon advance copy being served accepts notice on behalf of the opposite parties. Let one extra copy be served on the learned AGA to enable him to obtain instruction. The learned AGA seeks 2 weeks time to obtain instruction as prayed for, list after 2 weeks. Liberty to mention for listing before the assigned bench.
Obligation.
Yes.
Item 31. May it please your lordships. I am in VC, your lordship.
Yes.
This is a matter. Before I begin, your lordship, I have a small prayer.
Yes.
Because I had tried many times in the first hour to just log in, but actually I have not been allowed to do so by the concerned official.
So actually what has happened, somebody,
Yes.
I also see him for the first time. So he is struggling a bit.
Oh, I see.
Because I asked him to, just like he is struggling, so he may be excused for the day. Gradually he will learn. So I don't know whether he has experience in other courts.
Right. No, this only usually happens with court number 1, your lordship. Your lordship knows. Justice in that happens. But here, because I was trying to mention,
it is live, so there is no difficulty, but maybe some technical error or he didn't realize what was happening.
And another fact also I must tell before your lordship, that whenever we are appearing as a senior counselors also, the names are not properly noted in the order sheets. Orders.
Acha, then that I take care. I take personal care.
Yes.
I also check.
Because actually it is
while signing the order sheet also I check, and I have found out some other names have been mentioned.
Yes. That
initially I found out that some, because here the
all the persons are new. They don't know us also by in person.
Everyone knows Mr. Narendra Kumar, Mr. M.S.Sahoo Das, or all of you. But please mark, just say, you may not see that. Mr. Das can tell you.
Right.
You see where they are sitting. They do not see the screen.
Correct. Right.
They do not see the screen. So I had in fact rotated the screen a bit, but from a distance, from a different angle.
Okay.
The screen will not be visible. LCD or LED screen is not visible because they are completely I mean, you are actually, the entire screen is out of sight. Since I am sitting beside and they are addressing.
Your Lordship will remember once I also expressed before Justice Sinha that
Yes.
when I am arguing the cases also on behalf of the parties, Your Lordship records the name of my son also, because in the process he has become a senior advocate.
No, that's it. That's error of typing.
That's right.
You are absolutely right.
Yes.
They're right.
Still, it is continuing also. In many courts, that is continuing.
Arendra Kishore Mishra, Nitish Kumar Mishra, senior advocate.
Yes.
So that's a mistake. In fact, one senior advocate cannot instruct another senior advocate or advocate. So that is a mix-up. But the real challenge is,
yes.
So in fact, that is how I have developed from dictating that who is appearing, where he is appearing.
Yes.
He is addressing.
Your Lordship is very particular about this thing that I have been.
So I have realized, because I am using this paperless format, and after this, since I was daily appearing in the COVID period,
yes.
I used to have, in fact, 4 computers, because some courts like Justice Great Justice Sadangi's court, after one you cannot reach 21.
21, correct.
So usually what I used to do, 1 to 20, one computer, 21 to then next 40 or 40. Another computer, so that when the Lordship is going fast, because if you remember, they were allowing 20 cases at a time.
20 cases at a time, yes.
So you cannot relog after 20, because by the time you relog, Justice Sadangi will reach 51.
Yes.
So the entire
many times Gyana Babu are also not able to cope up with the court.
No, Gyana Babu cannot. Gyana Babu cannot.
Correct. Thank you.
Gyana Babu, I know him from his school. I know he's again from my school, where I passed my matriculation. He cannot, very few can match his speed. But I also had developed this, that if I want to appear from 1 to 50, then I need to have at least 2 computers.
2 computers, right.
So that experience is now helping me.
Correct.
And then the other part is that we are so scared, or in fact, it is not possible to seek any kind of assistance. But the senior counsel who is appearing, or you are appearing, you are not having a computer assistant. I am having one is managing the video conferencing, and one is there to assist also.
Right.
So your resources and resources and personnel is also, it is difficult to manage the whole thing. So Narendra Mishra, senior counsel, instructed by Mr. N.K. Nitish Mishra, for the petitioner, Mr. Bimbis Das, AGA for the state.
So this is a matter for regularization of an ad hoc employee who has been continuing since 1994 as octroi peon.
Yes.
And this is actually, in fact, the 3rd round of litigation for regulation purposes. Your Lordship may kindly come to directly to page number 10, the last occasion.
Just 1 second. I'm just interrupting.
Sure.
First hour रे कोर्ट रे मेंशनिंग होची कोर्ट आरंभ होला पर अपन चलला तो सेतोळे अपन संग अलाउ करे पड़े सो दैट दे कैन मेंशन सेतोळे किछि नंबर नाही अगेन बिफोर राइजिंग आल्सो आज गोटे 20-25 रे आउथरे मेंशन हला देन यू हैव टू अलाउ एवरीवन देन एट 2 आल्सो अगेन देयर इज अ मेंशन टी अधिका ही होची बट स्टिल देन यू हैव टू अलाउ देम हला यस
by learning senior starts.
Your Lordship may kindly come to
Lecture 2 the issue is motte visible nahi.
Achha, I will note that. He says that his annexure 2 is not visible.
Not at all visible.
Annexure 2.
But the impugned order is at annexure 5.
5. 2
टा आपनकर
आउथरे दे देबी सर देखि
पढा हे जाइछि हां ठीक अछि
आउथरे दे देबी
I'll
sure
I'll take note of that in my order. Yes.
Sir, your Lordship may kindly come to page 10, para 11. I have quoted that order passed by this Honorable Court in the earlier writ petition 8417 of 2023.
Yes.
Considering that is on 27/3/23. Considering the limited nature of grievance of the petitioner, the writ application is disposed of at the stage of admission with a direction to the opposite part number 1 to consider the representation of the petitioner under Annexure 4 in accordance with law within a period of 2 months from the date of production of certified copy of this order.
Yes.
The opposite part number 1 shall do well to dispose of the representation of the petitioner under Annexure 4 by passing a speaking and reasoned order. While considering the representation of the petitioner under Annexure 4, the opposite part number 1 shall do well to take into consideration the fact that the benefit as claimed by the petitioner has already been extended in favor of the similarly situated employees. Your Lordship, what has happened? There are many employees has been engaged as ad hoc employees, is as an ad hoc peon and octroi peon, Your Lordship, octroi peon and octroi collectors. Many of them have been also regularized by now, and the petitioner has been deprived of the benefits, Your Lordship. That is why I have been repeatedly approaching this Honorable Court.
Yes.
And Your Lordship finds in Annexure 5,
Yes, please.
the order has been passed because no personal hearing was made to me, so I could not appear. I could not place my cards also. Only the representation was there. And the last occasions, Your Lordship says, page 36, Your Lordship may kindly have a look at page 36. As a matter of fact, that para.
Yes, please.
As a matter of fact, the petitioner
Vibhushan Tandi.
Yes, was engaged as octroi tax collector on 26/9/1994, purely on a temporary basis for a period of 6 months. Although the said engagement was extended from time to time, even after abolition of octroi tax, yet said engagement of the petitioner Sri Vibhushan Swamy was not against any sanctioned post, for which he is not at all entitled to claim regularization of service merely on the ground for continuing for decades by claiming himself as similarly situated employee like others. Because my contention has been, we have been appointed against the similarly situated persons and also against sanctioned posts, which have been approved by the Municipal Council, Your Lordship.
Yes.
And earlier they say, just the previous para, Your Lordship sees,
yes,
the fact remains, just 5-4 lines.
So your case is that they have not taken into consideration the relevant materials on record.
Yes. And
because,
I think
because the earlier writ petition gave them a kind of free hand to decide actually.
Yes.
The writ petition did not observe anything on merits.
No.
So you take notice.
Yeah, I'll have to take. Yes, I'll have to take.
Appearance likely. Tapare had the learned senior counsel. Had learned senior counsel for the petitioner. The petitioner is agreed by the order dated 11th of August 2023, passed by the OP number 1.
Yes.
Rejecting the claim of the petitioner for regularization of service in the establishment of
OP number 3.
OP number?
Municipality. OP number 3, Your Lordship.
OP number 3. OP number 3.
Yes.
It is submitted by the learned senior counsel that while considering the matter, the petitioner was not heard in as much as there is a direction by the court to dispose of the matter.
Representation.
To dispose of the representation filed earlier by the petitioner. Therefore, several material aspects could not be brought to the notice of the authority deciding the matter. It is submitted that the materials on record have not been considered and certain relevant aspects have been ignored while deciding the representation of the petitioner. While deciding, while adjudicating the representation of the petitioner. Issue notice along with this order. Then para. The learned AGA upon advance copy being served appears on behalf of the opposite parties 1 and 2. Waives notice. Let 2 extra copies be served on the learned AGA to enable him to obtain instruction and file counter. Issue notice to OP number 3 and 4 by registered post/speed post with AD. Requisites for issuance of notice
3 working days.
Be filed within 3 working days.
Right.
The opposite party number 3 and 4 shall have the liberty to file their response on the date of appearance. The learned AGA 4 weeks time. 4 weeks time to obtain instruction and file counter. on behalf of OP number 1 and 2. As prayed for, counter be filed within 4 weeks. Upon copy, upon serving copy thereof on the learned instructing counsel for the petitioner shall have the liberty to file rejoinder.
Yeah, great.
Liberty to mention for listing before the assigned bench.
Great.
Yes, please. Next.
32. Sir, may I please?
Mr. Annamcharan Panda, AC Panda for the petitioner. Mr. Bimbisar Das, AGA for the state. Yes, Mr. Panda.
Lord sir, limited prayer, Lord sir, direction to the ASO to accept the application and adjudicate the same in accordance with law, my lords.
Accept physical acceptance.
Yes, your lordship.
It can't be filed and numbered.
No, they have not accepted it, lords.
Who provision ଅଛି ସେଟା?
Lords, Annexure 1.
No, this is academic. Yes, Annexure 1 is the application.
Yes.
But you are saying that he's not accepting, but I mean, there is no system of like a court. It has to be numbered.
No, it will be filed before the office, my lords. My lords, they will put the application before the ASO. Lords, he will endorse it upon it, and then it will be accepted. That is the procedure, lords.
The hard learned counsel appearance likely. Hard learned counsel for the petitioner. It is submitted that the petitioner raises a limited grievance to the extent that his application under Section 12 of the Orissa Survey Settlement Act 1958 is to be accepted by the authority, that is the Assistant Settlement Officer, Major Settlement, Kotak. On being asked, it is submitted that though the application is filed in the office, but it has not been yet accepted as required under law, or as per the procedure prescribed. As per the procedure prescribed. The learned AGA seeks accommodation to obtain instruction. As prayed for, list after 2 weeks, liberty to mention for listing before the assigned bench. If it is accepted for adjudication, your grievance is met. Then whatever may be the result.
Similar orders passed by the coordinate bench, if your lordship.
Better that you mark the age, he is 80 years. Another matter, somebody, Mr. Guru, he said that let the, but without, it is better they should obtain instruction and to take a definite path actually. The petitioner is 8 years, he has to wait for some more time. You never know what would happen once it is disposed of. Yes, next.
33. Contempt, my lord.
Yes.
My lordship's order has not been complied till date. Though I had submitted through a representation. My lordship's order is...
Order.
Order I have quoted, my lord, page 3.
Copy now.
Entire order.
It is available in the web, na? It has become so easy. So order ta refer quality ke?
I have quoted the entire order.
WPC number ke kadi paribeti achandi? WPC 17303 of 2012.
Is that UGC matter in which my lordship directed that it was covered by lord?
Yes.
In many cases, they have started implementing, but
no, I have to check whether I have jurisdiction. As per the assignment, I think it has to go before the judge who has passed it, or the assigned bench. Now, Barike Udyon to assignment. 80 achi. WPC 17303. थोड़ा ऊपर को जान तो W को जान तो W OAB नो PC हाँ सेटा नंबर पकान तो 17303 2012 disposal date होची 17.08.2023 ତଳକୁ ଆସନ୍ତୁ ପ୍ରିଣ୍ଟ ହେଇପାରିବ ପ୍ରିଣ୍ଟ କରିଦିଅନ୍ତୁ ସେପଟେ ହବ ଠିକ ଅଛି ଯୋଉଠି ପଠେଇକି କଣ ଲ୍ୟାଣ୍ଡରେ ଅଛି ପେଣ୍ଡ୍ରାଇଭରେ ନେବେ ନହେଲେ ସେଠି କାଢିକି ପ୍ରିଣ୍ଟ କରିଦିଅନ୍ତୁ କାଉନ୍ସିଲ କଣ ଲେଖିଲେ Mr. Devendranath Misra. Mr. Upon DN na D
DN.
Mr. DN Misra for the petitioner. Mr. Bimbisar Das AGA for the state. It is submitted by the London Council for the petitioner. The contempt application has been filed in view of for the fact that the order dated 17/8/2023 passed by this bench in WPC number 17303 of 2012 has not been complied with. Chapano evidence kon dele communicate hela boli.
Well, annexure 1 series by lot of given to post types and
As a postal receipt.
In the office I've handed over my lord. That endorsement. Endorsement in the page 9, 10, page 10.
10 nahi the.
My lord.
Jo receiving lekha hai chi.
My lord.
Yes, Mr. Das.
Yes, my lord, I've seen that.
He's Mr. Misra is referring to the right side endorsement.
Yes, I've seen that.
Yes. Date endorsement date ta टिके देखा जाए 24/8/2023
24/8/23
complied with. The London Council for the petitioner submits that he has quoted the order in the petition and also produces a copy thereof. Referring to page 10 of the petition into bracket annexure 1 series, it is submitted that the order was duly communicated as would be evident from the endorsement dated 24th August 2023 by the receiving officer, Higher Education Department. The learned AGA in response seeks time to obtain instructions regarding compliance of the order.
Again.
How much time?
2 weeks. 2 weeks I'll take it. As to why it has not been implemented.
As prayed for, list after 2 weeks. Here both. Here both the director and secretary, or the only one is to be noticed?
Director and secretary.
Both. The London AGA appears on behalf of the opposite parties upon advance.
Little bit more time than required.
Appears upon advance copy being served and waives notice, seeks accommodation to obtain instruction regarding compliance of the order as prayed for, list after 6 weeks. Liberty to mention for listing. Upon 6 weeks diyontuni. That will deal with the process. You know how we do it.
I learned that while I was there in the central government. I used to write that.
Yes.
Nobody taught me. I used to write that. Unless
and now you will find the same thing in your present assignment.
Yes.
That तो original था. अपन फाइल टा कॉल फॉर ही चना कौन. ठीक है. सुने से कंप्यूटर काट देवे था ना लगे देवे.
Unless we write that Hon'Ble Court expressed total displeasure in content matters, we cannot meet the situation.
Yes, please. Next.
34.
Mr. J. Biswal for the petitioner, Mr. Bimbisar Das, AGA for the state, Learned Counsel for the petitioner 6 accommodation as prayed for. List after 1 week, liberty to mention for listing before the assigned bench.
35,
Same order. J. Biswal, Mr. Das. Same order.
36,
Mr. Swayam Prabhu Jenna for the petitioner. This you did not mention, Acha.
No, ma'am.
Acha.
40 I have mentioned.
Just a second. Mr. Bimbisar Das, AGA for the state. Yes.
Yes, ma'am. The petitioner's prayer is for disbursement of his family of a family pension, DCRG and unutilized leave salary.
Okay.
For the petitioner's prayer is for family pension with effect from 1/8/2015, my lord. Her son, while serving as a headmaster in that is in Sadhu Sundar Vidyapitha Tangi, died on 17/7/2015. Thereafter, she has not received family pension for which she has represented by Annexure 7, my lord.
See, her son is not survived by any other legal heir. Class 1.
Legal heir is mother, Annexure 6, page 20.
No, that I understand. But my question is very specific. That there is no other surviving legal heir other than the mother.
No, my lord, no others.
Where you have stated that?
My lord,
in
I
the
have
petition.
stated that in paragraph. That is that. Paragraph 7, my lord. Page 5. It starts from page 5. Paragraph 7. That the son of the petitioner, late Krishna Chandra Behera, married to Sangita Gochait, but he did not pull well with his wife, for which both of them obtained mutual divorce, and such decree was granted by the learned family judge Katak in CP number 143 of 98, by order date 2010-98, and while continuing as headmaster in Vidyapitha Tangi, due to illness, expired on 17/7/2015, leaving behind his mother, that is the petitioner, and his brother children. Further, the mother of the petition, that is the petitioner, is the only legal heir.
Brother, family pension is not meant for brothers.
No, not they only have
you may say
taken the
about the
appointment.
estate, and it's not a estate as far as. Why Anchandi?
My lord, I do not have the.
Okay. The surviving mother is entitled for family pension as defined under section 50 rule 56 of Orissa pension rules. The OCS pension rules of the OCS into bracket pension rules bracket closed tapare rules comma 1992. The learned counsel for the petitioner was heard in some detail stuff. So para he seeks further accommodation to examine the provision of law as mandated under rule 17 into brackets small English B into bracket small Roman I. Read with the note dash into bracket small Roman I. As prayed for list after
1 week after.
List after a week. Liberty to mention for listing before the assigned bench. Yes.
37.
Because the
May I
principle
please
is also logical, Mr. Jena. Resume Karanto. The issue is that the wife is entitled for the status she was enjoying pre-divorce. So for the period she was married, she was enjoying some status. Even if you think in the term of permanent alimony also, that is how the pension rule doesn't deprive the divorced husband or wife. Either way. Yes.
May I please, Your Lordship?
And you have to check some case law also. Mr. Rajiv Lochan Patnaik, R.L. Patnaik for the
Yes,
petition.
ma'am. Yes, ma'am. May I please, Your Lordship?
Mr.
In this case,
Opposite party blank. Yes, Mr. Patnaik.
the petitioner was working as a peon, temporary peon under the opposite party matter. But
Yes.
when he demand his labor wages, thereafter on dated 24/1/2024, the opposite party orally terminated the present petitioner matter.
He was a daily wager.
Yes, Your Lordship. Yes.
So did you raise a industrial dispute?
No, madam.
So will it be beneficial for the petitioner to pursue this litigation extraordinary because it's a summary procedure?
Yes, my lord. But my humble only prayer, my lord, annexed to the reference, kindly target some time to dispose the
The petitioner will be satisfied with the disposal of annexure 2?
Yes, Your Lordship.
Will it serve its purpose? Will he get anything out of it?
No, ma'am. They till that, my lord, they did not allow the petitioner to join
It's up
the.
to you. I cannot compel anyone for that matter. Any petitioner that he should pursue the remedy in particular way if you want disposal of implementation. But since I'm really concerned about this kind of a situation where he goes on a journey on a road to nowhere. So that is why I'm asking before passing the order. It's up to you. The petitioner will be satisfied.
Yes,
that is your advice. That is your instruction rather.
My lord.
Opposite party blank likely. It is submitted by the learned counsel for the petitioner that the petitioner raises a limited grievance. ଆପଣ 5th January फाइल कले 24 अच्छा भाई for seeking a direction for disposal of his representation dated 5th of January 2024 pending before the authority, pending before the opposite party authority under whose establishment the petitioner was working. Se koti kama korthile?
Temporary peon at Union Bank Kotpad man.
Authority padle sentence ta? Authority stop kar diyo. Full stop. Tapar katti diyo. Tapar lekhontu. It is submitted that the petitioner, while working in the establishment of open number 2, was removed from service. As a casual worker. Quote kar diyo, single quotation, housekeeping peon. Or peon, just whatever pronunciation, P-E-O-N, was removed from service. He stopped for redressal of his grievances. He had made a representation dated 5th of January 2024, marked as Annexure 2 and annexed to the writ petition, which is still pending disposal. Having heard the learned counsel for the petitioner, considering the limited nature of grievance raised, the writ petition is disposed of without issuing notice to the opposite parties. Observing that the opposite parties shall do well to consider the grievance of the petitioner and take appropriate decision in accordance with law for redressal of the grievance. Within 8 weeks from date of communication of the certified copy of this order, along with copy of the representation into bracket small s. The writ petition is disposed of accordingly. Lekhontu, it is clarified that this court has not expressed any opinion regarding merits of the case or contention of the parties to the writ petition. Yes.
38.
Mr. UK Sahu. You are writing UK or you?
You Sahoo.
You will. You dot, then that is correct. Grammatically, you is correct. Mr. U Sahu, U dot Sahu for the petitioner, Mr. Bimbisar Das, AJ for the state. Yes, Mr. Sahu.
My lord, this is matter of regulation service. It's the third time litigation, my lord, because I am Annexure 6.
How many times you have represented? And orders have been passed to consider representation?
2 times. Last time also passed the order on that only 45, my lord.
Yes.
That is the order passed by the without any counter rejoinder.
Yes.
But the same has been disposed of in Annexure 8, which is a common order that I am under self-financing.
What about Annexure 6, page 43?
Annexure 6 it was another order though, that was in previously my
Your
representation was
yes.
considered by.
Yes, that was rejection of representation.
That was rejected.
That was challenged.
That was challenged.
So thereafter what happened? That was challenged in OA or writ petition? Writ petition, because in 24.
But another given liberty to consider in according to one cited a case, but they have not considered my case. So Annexure 8 is the rejection of present.
This Annexure page 43 was challenged before the writ petition in a writ petition. So kindly show that order.
That was
Page 45.
My lord. That was
Page 45.
45. Last paragraph, paragraph 4. In view of such submission made by the learned counsel appearing for the party while passing the order letter so and so and straight in the present disposal in light of so and so. But in light of so and so, but they have not considered my case. So the another cause of action.
So your contention is there was all darkness, no light.
Yes.
Yes, Mr. Das, no light. What can be done?
From page
It is something
45.
like the yesterday in the international match, all lights were gone. It is made a national issue, and they say that for the next 2 years, there should not be any match.
Yes, yes.
But because you are the umpire, what you would have done?
Earlier that had happened.
So, order dictate korche apna asijiba katha na. Mr. Das is a certified lawyer of the BCCI, umpire of the BCCI. So, with whom I will discuss regarding the light and all that. Yes.
Well, I'm challenging Annexure 6.
Yes.
DPC was constituted. My case was not considered for promotion. For that reason, I have represented. And earlier, I have filed a writ application.
Mr. Mahanti, one clarification. I'm interrupting you.
Yes, fine.
It is you have been considered and kept in sealed cover or not at all considered?
I was considered.
Considered and kept in sealed cover?
Consider, but my name was not found place in the select list. For that reason, I filed a representation.
Your name did not find place in the select list?
Select list, in the DPC.
Acha, you filed a representation?
I filed a representation.
Yes.
During pendency of the litigation, I have filed a writ application before this Honorable Court. Honorable Court directed to dispose of my representation.
Yes.
And Annexure 6 is under challenge. He has taken a decision that the DPC constituted by them are correct, and for that reason rejected my petition, which is under challenge.
Appearance likely. Hard running counsel for the petitioner. It is submitted that the petitioner is agreed by not being given promotion to the post of
Head checker.
Head checker. From the post of
Circle checker.
Circle checker. Circle. Goal. Post of circle checker. While working in Padampur. Into bracket Kendulif. Bracket closed. Range. It is further submitted that the petitioner had the petitioner, after not being considered for promotion, upon consider he reject ele. The change korantu. Change koruchi. The petitioner having not got promotion, made a representation annexed as Annexer 5,
Annexure 6.
Annexer 6.
My
Annexer 6 ଟା order.
order.
ମୁଁ ଆପଣଙ୍କୁ representation ପଚାରୁଛି.
Sir, my lord, earlier I have filed this is Annexure 2, my lord.
କଣ ଲେଖିଲେ? Dated 5th of November.
5/11 to
ଆପଣଙ୍କର ଇଂଲିଶ ନା ଓଡ଼ିଆ ମିଡିୟମ? ଆପଣଙ୍କର ଇଂଲିଶ ମିଡିୟମ ନା ଓଡ଼ିଆ ମିଡିୟମ?
ଇଂଲିଶ।
ମୁଁ ତ ସେଟା 88 ଭଳିଆ ଦେଖାଯାଉଛି। 5/11 ନା 5/88 ସେଟା?
5/11
5/11/2024
28 ମାସଟା ହେଇଥିବ 11
ହେଇଥିବ ସେ ହଁ ଠିକ ଅଛି ସେ ଲେଖିଛନ୍ତି 8/8 ଲେଖିଛନ୍ତି ଠିକ ଅଛି। କଣ ଲେଖିଲେ? Address to the OP number, appropriate authority, OP number
2.
OP number 2, Chief CCF.
CCF.
CCF, copy of the said petition is annexed to the writ petition marked as Annexure 2. During pendency of the representation, the petitioner approached this court by filing WPC number 28184 of 2024, which was disposed of by order dated 2011-2024, directing the authority to consider and pass necessary orders in the representation. Thereafter, the authority has passed order dated 11th December 2024 into bracket Annexure 6, rejecting the claim of the petitioner for promotion. It is submitted that the petitioner, though otherwise entitled to get promotion, being qualified with regard to the prevailing rules, his case has been rejected. Para. Issue notice along with this order to the opposite parties 1, 2, and 3, because 4 is the immediate junior.
Junior.
Immediate junior. No notice required to him.
Notice maybe.
Why he is not affected? So stage ASU. He is the only candidate.
Only candidate.
Yes.
One submission, my lords. The only claim of
Just kindly speak to the microphone.
Only claim of the petitioner is that he's senior to the person who has been appointed. Opposite party number 4. In the impugned order, the date of joining and the date of birth of both the candidates were considered, and thereafter they have rejected the representation of the petitioner. And opposite party number 4 was correctly held that correctly appointed to that post.
It's good that you have read the brief. So and you should keep it up. Always look at the brief. But here the point would be in the cadre when whether both of them they may have joined on a different dates. But the cadre will matter. The entry level, not the entry level cadre, but the cadre where they are now situated. So that is to be examined. One, two, three. So there may be some subsequent promotion, there can be reorganization of the cadre, or maybe there is a possibility of inter-cadre, like Kendulif and say or some other say in forest it is wildlife division is there, Kendulif division is there. There are so many divisions. And if it is a district level cadre, then there will be something different. Issue notice along with this order to the opposite parties, the learned ASC, upon advance copy served, appears and waives notice on behalf of OP number 1, 2, and 3. So notice to OP number 4 along with this order by speed post / registered post with AD. ଆପଣ ମୋତେ ଆଗ ରେଜିଷ୍ଟର୍ଡ ଲେଖୁଛନ୍ତି registered / speed post with AD, requisites for issuance of notice within 5 working days. Within 5 working days. So I'm saying working days. So the holidays excluded. 5 working days. The learned AC 4 weeks time to file counter. As prayed for, counter will be filed within 4 weeks. Upon serving copy thereof on the learned counsel for the petitioner shall have liberty to file rejoinder. Liberty to mention for listing before the assigned bench. Yes, text please. Mr. Swayam Prabhu Jena for the petitioner. कितने दिन टाइम मांगी थे?
Next week.
Next week. Learned counsel for the petitioner seeks accommodation. As prayed for, list after a week. Liberty to mention for listing before the assigned bench.
T1.
Mr. इतने लिखिए 40 लिखिले 40 टा की लिखिले पण स्वयं प्रभु जेना and Miss Aishwarya Das lecture in appearance की लिखियो हाँ. See, today actually a learned senior counsel said that the names are not being reflected, though, but you can't see this. That is how I have to ask you always that upon the done ki likhuntu. Then 41, Mr. A.K. Behra for the petitioner, Miss Aishwarya Das, AC for the state. Learned counsel for the petitioner seeks accommodation. As paid for, list after a week. Liberty to mention for listing before the assigned bench.
42
42 से डिक्टेशन नहीं चलती तो नहीं मोर ऑर्डर माने अच्छी ठीक है
43.
Yes, Mr. M.K. Khutia. Yes, please.
Yeah, please. The second round of litigation.
Yes.
Earlier, I have approved my lots in WPC OSC number 503 of 2019.
Yes.
That was disposed of with a direction to consider my representation.
Yes.
That has been rejected. I have annexed at page 27.
Yes.
Rejection order.
Yes. The prayer is for?
For antedating my appointment to 2013.
You take notice. Yes. Since it has already been rejected and there is no appeal provision.
No, man.
In departmental appeal जो पुलिस रे था है, it is only for constables, it is not there.
No. Departmental with punishment.
No, I am not saying about punishment. तांकर बेले बेले आपनकर थाए होम गार्ड करो से कांस्टेबल करो to SP then DG. Here it is not there. Yes. Because then there will be wastage of time. They will simply come and say that the appeal lies to DG, let it be disposed of. But anyway, take notice. The item kete option 43, Mr. M.K. Khuntia for the petitioner, Miss A. Das, AC for the state, had learned counsel for the petitioner. It is submitted by the learned counsel for the petitioner that the petitioner is aggrieved by the rejection of his prayer for antedating his appointment to 2013. Though his date of though no सेटा कोन आपण प्रोटेस्ट करथिले जो रेकॉर्ड हिचे ना नहीं
आगे सेटा मु केस प्रथमे करथिले होछि 2013 रे मोटर कम मार्क रखते पिला को देले मते देलेनी ट्रिब्यूनल कहला हमको चाकरी
जगत सिंहपुर
आगे ट्रिब्यूनल कहला हमको चाकरी दियो
that came to high court
then they implemented it that case is different
कौन लिखले antedating what a category. It's not exactly a case of antedating. Actually, you are saying that your date of appointment should be the year of recruitment.
Yes, no. When others were appointed.
Others are
and less meritorious.
The rejection of his prayer to give the date of appointment of the petitioner as 2013 for the fact that the persons who had competed with the petitioner got appointment in the year 2013.
Securing less mark. Securing less mark.
Just a second. In 2013, the petitioner, as was not selected, challenged the same. Just use the microphone. At times, I'm missing your address. कौन लिख ले? As the petitioner was not selected, he challenged his non-selection in OA number 2852C of 2013. That OA was disposed of, or it came to High Court?
No, that was not come to High Court.
The OA was disposed of, granting relief to the petitioner for getting appointment. However, the petitioner was given appointment reflecting his year of appointment to be 2017 instead of 2013.
Yes.
Sorry, as 2013 instead of 2017. They submitted that earlier this court had directed to the issue notice on admission, issue notice the learned ASC. The learned ASC appears on behalf of the opposite parties upon advance copy served and waives notice. You require extra copies, Ms. Das. The learned AC seeks 3 or 4 weeks time to obtain instruction and file counter. As prayed for, counter on behalf of the opposite parties be filed within 4 weeks. Upon serving copy thereof on the learned counsel for the petitioner, petitioner shall have the liberty to file rejoinder. List after readings are complete, liberty to mention for listing.
44.
Ms. Sujata Jana for the petitioner. Opposite party blank, yes.
Annexure 8 is under challenge.
Yes.
In refusing to grant pension, the Lordship may kindly see the paragraph 5 of that order.
Yes.
Must not have been seen such type of order. My lord, he has been regularized. Similarly situated persons have already been granted pension. And 5, it is worth mentioning here that the Utkal University is state funding university and it depends upon the state government's release through the annual block grant to meet the salary component and pensionary benefit of the regular teaching and non-teaching employees. The regularization of the service of the petitioner has already put pressure on the university's own fund as the salary and other emoluments are being met out of the reject.
ମାନେ ଆପଣଙ୍କର ଏଟା ଗୋଟେ ଇଂଲିଶ ଆପଣ ଇଂଲିଶ ପାଇଁ ଏଟାକୁ ମାନେ କହୁଛନ୍ତି ନା କଣ ଇଂଲିଶ ଭୁଲ ହେଇଗଲା ବୋଲି
ଇଂଲିଶ ନାହିଁ ଏମିତି ରିଜନିଂ କୋଉଠି ଦେଖିଛନ୍ତି କି
had the learned counsel for the petitioner the learned counsel for the petitioner the petitioner is agreed by the order dated 9/12/2024 rejecting his prayer for pension. It is submitted by the learned counsel for the petitioner that the order dated 9/12/2024 into bracket annexure 8 does not disclose any other reason apart from the purported lack of finances as indicated in para 5. It is submitted that if the petitioner is otherwise entitled for receiving pension as per the prevailing rules, the same cannot be denied on the purported reasons as indicated in paragraph 5 of the impugned order.
Specifically when similarly situated persons have already been granted pension.
Stop. It is submitted that similarly situated persons have been granted pensionary benefits and the petitioner has been discriminated to that extent. Issue notice along with this order to the opposite parties. Requisites for issuance of notice by registered / speed post be filed within 5 working days. The opposite parties shall have liberty to file their response on the date of appearance. Upon serving copy thereof on the learned counsel for the petitioner shall have liberty to file rejoinder. Liberty to mention for listing before the assigned bench.
Oh, bless.
Yes.
45.
Mr. D.N. Misra for the petitioner, Mr. Miss Aishwarya Das, A. Das for the AC for the state. Yes, Mr. Misra.
My lord, I am already working from 93. 31 years I have completed. I have been granted temporary status in 2013.
Yes.
And now they have regularized persons who are working, number of working days are less than me. Though I'm in senior position, they are not regulation. I'm not claiming any against them, the petitioners who have been, but I'm claiming regulation from the date of.
And going to the labor court will not benefit you.
No, my lord, labor court will not benefit.
Because factual adjudication becomes very difficult. They simply deny whatever you say. You cannot adduce evidence.
My lord, they're
The
difficult.
read being a summary proceeding. In these kind of claims, it becomes very difficult.
My lord.
Anyway, it is your choice. It is only a discussion. So, thinking aloud. कौन लिख ले? Appearance लिख ले. There it is hard learned counsel for the petitioner. The petitioner is agreed by non-regularization of his services in the capacity of casual/daily wage worker.
Granted with temporary status.
Having been granted temporary status
from 2013.
In the year 2013.
Well.
In the establishment of OP number 3. It is submitted that the petitioner is engaged in continuous work for the last 31 years. Stop recently, comma. Persons having less number of working days. The persons who have worked for a lesser period have been regularized in services. It is submitted though posts are available and work is of perennial nature and petitioner has been rendering the work uninterruptedly for the last 31 years. He is deprived of his legitimate expectation for getting regularized. Para issue notice along with this order. The learned AC, upon advance copy served, appears and waives notice on behalf of the opposite parties.
Opposite party number 1 and 2, my lords. No.
3 is actually your establishment. But she has pointed correctly. But you have not mentioned director or something, or who is there?
And actually, we are under the regional plant resource.
You should have mentioned director or DFO or ACF, whatever. Who is in the charge of that?
OP number 2, my lord, director environment and come special secretary to government.
No. Plant resource center is immediate employer is under some kind of a thing.
Immediate is regional plant research center, my lord.
I understand, sir. Represented by the director or the DFO or who is the officer who is heading that office?
Regional, my lord. Regional.
No. Director doesn't head any office. He's head of the department. Like the last matter. Suppose university under the director higher education. Can it be? Apna proper party kori nahanti.
And they are issuing actually regional open up.
ମୁଁ କହିଦେବି ଆପଣ କହୁନାହାନ୍ତି କୋଉ ଅର୍ଡରଟା ଇମ୍ପ୍ଲିମେଣ୍ଟ ବୋଲି.
Annex 3 Annex 3 series they have regularized person.
ଦେଖନ୍ତୁ 17 ରେ ଦେଖନ୍ତୁ କଣ ଲେଖା ହେଇଛି. Page 17.
Right.
ଆପଣଙ୍କର ଅଲଗା ଅଛି କି?
No, madam. Chief executive.
Chief executive. ତାପରେ ଦେଖନ୍ତୁ chief executive.
Director environment. Then copy forward to director environment.
Yes. If he is the authority, he forwarded the third copy to himself.
No, my lord, that is OP number 2. I have made him OP number 2, my lord.
Chief executive.
No, chief executive I have not done.
Opening sentence lekhantu, the learned counsel for the petitioner submits that inadvertently the description of the opposite party number 3 is not complete and he may be permitted to carry out necessary correction in the cause title of the petition by indicating by carrying out the correction at by carrying out correction in the description of OP number 3, which is to be corrected as Regional Plant Resource Center, represented through the Chief Executive. Represented through the Chief Executive. Prayer is allowed. The Learned Council is granted leave to make the carry out the necessary corrections. Volume कमी दियंतु. एटा echo होच. More जो speaker है. Carry out the necessary corrections to be countersigned by the court master. Mr. Barik. दियंतु. तापरे लेखन्तु कोन लेखले? Let parties let 3 extra copies be served on the allotted DSC to enable her to obtain instruction and file counter. The allotted DSC seeks 4 weeks time to file counter. As prayed for, counter be filed within 4 weeks. Upon serving copy thereof on the Learned Council for the petitioner, the petitioner shall have the liberty to file legenda. List after pleadings are complete. Liberty to mention for listing before the assigned bench.
46.
हाँ, appearing counsel किए थे Bishwal. Mr. J. Bishwal, Jagadish Bishwal for the petitioner. Mr. J. Bishwal for the petitioner. Ms. Aishwarya Das AC for the state. And counsel for the petitioner 6 accommodation as prayed for. List after 1 week. Liberty to mention for listing before the assigned bench. Yes. Mr. Mishra, so I am audible that side. I am audible that side. My voice is coming. Yes. 47 petitioner none. Ms. Das AC for the state. None appears for the petitioner when the matter is called to grant further opportunity.
47 RN Baring.
Upon lecture, the more lecture parni.
47 was mentioned.
Mentioned. He is saying the same thing. Mr. R.N. Barik. Mr. R.N. Barik on behalf of G.K. Nanda for the petitioner. Ms. A. Das AC for the state. Learned Council for the petitioner 6 accommodation. As prayed for list after a week. Liberty to mention for listing before the assigned bench.
48.
Mr. Bhuya. Mr. S.S. Bhuya for the petitioner. Ms. A. Das AGA for the state.
If I may please, your lordship. The order wide annexure 8 is under challenge.
Yes.
Wherein the municipal authorities have initiated a UC proceeding under the ODA Act,
Achha.
Section 91 and 92. Even though the land in question is recorded in the name of the father of the present petitioner, and there are other stakeholders in that said property, the UC proceeding has only been initiated against the petitioner. Keeping all that in mind, 2 petitions were introduced before the adjudicating authority, my lord. One under Annexure 6, wherein the preliminary maintainability of the said proceeding was challenged on the grounds that first, municipal authorities cannot invoke the power under the ODA Act, and the second is non-joinder of necessary parties.
Yes.
Another petition was also introduced by Annexure 7, wherein
no, there is a decision that ODA lacks authority after that constitutional amendment.
I am not aware about the judgment, but as such, my lord, the Municipal Corporation Act being a subsequent act does not have the enabling provision allowing the statutory authorities established by it to utilize the act.
They brought an amendment after that pronouncement of division bench by Justice B.P. Das and maybe Justice B.K. Naik. I am not sure, but it was presided regarding Bhuvaneshwar. So that was confirmed by Supreme Court that there is no provision in the Municipal Corporation Act for taking out this Development Authority Act. Mutatis mutandis, there has to be a provision like Development Authority Act. So in void, they cannot initiate. So thereafter, what you have to examine that. But you have sufficient case, maybe ground for issuing notice.
Because
But then what happened?
then what happened? I also introduced a petition seeking to prevent the complainant being an intervener to participate in this said proceeding because it is directly covered by the judgment of this Honorable Court passed in Khirodini Sahoo, wherein it has been stated that the complainant is not a necessary party.
Right, because it is a statutory violation. She cannot. You see, these question I asked somebody that what is the role of an informant in a criminal case. So that is being taken exception to. And the best part is that on the same day, one learned counsel argues that in Development Authority Act, it's adversarial proceeding against the authority. The complainant at best he has no role because that's the statute. Because individuals cannot pursue these kind of litigation regarding deviation and town planning.
His role ends once
Till he brings the complaint.
Yes,
the day he brings the complaint, that's end. That ends.
That is the end. It is before the authority. It is between.
Yes, because authority investigates and measurement and nomin and all that reports everything.
To that effect, he has passed the order, wherein both the said petition has been rejected. The intervener, the prevention of intervener petition that has been rejected on the ground that as complainant cum intervener is treated as a whistleblower to identify the areas where the provisions of OD Act laws enforcement and its violation as regards to the mental ability, it is that is the only part.
So blowing the whistle regarding whom?
With regards to the alleged construction.
No, they are too honest.
Yes, ma'am.
They are too honest. Blowing the whistle regarding the authorities, because these are violations. Non-compliance is attributable to the authority. There can't be a whistleblower.
Yes, my lord. And with regards to the
this is a deviation from a approved plan or it's a fresh construction without plan.
I was carrying out. It is actually, my lord, intersect disputes between the neighbors. One was constructing, one was making reparation to his old building inside that Bhasa Coast. Hence, the neighbor complained that they are carrying out construction without any approval. That was the initial allegation.
So your first submission is that municipal authority lacks authority.
The municipal authority, under the Municipal Act, they have the equivalent provisions which are empowering them.
Corporation. I stand corrected. Corporation Act. Corporation authority lack authority to initiate such OD proceeding.
ODA proceeding. Because in this said impugned order, he has relied upon a notification. If my lord may peruse, it is fourth line from the bottom.
Page
27.
Yes.
This is by virtue of notification number such and such has empowered the CMC authority to undertake the proceeding under OD Act.
Oh.
So the question, another question that I put to myself.
So they cannot. Yes, that's the other point. But that's a much bigger point. Or now I should take note of that.
My lord.
Because OD being a delegatee, it cannot redelegate.
Right.
In the Delhi Laws Act. Delegatus non potest delegere.
No.
That principle. कौन लिख ले? किसी लिखी नहीं Hard learned counsel for the petitioner. Appearance लिख चंदी तो. हाँ. The hard learned counsel for the petitioner, it is submitted that the petitioner is agreed by the order dated 20th of December 24, passed by the municipal authority of the municipal corporation. The authority under the municipal corporation, under the Municipal Corporation Act, initiating a proceeding under the Development Authority Act, that is the power to be exercised by Cuttack Development Authority. It is submitted that the petitioner is further agreed by the orders dated Now please come to those petitions, orders.
The petitions, my lord,
That order is only,
the order is of 20th December
the same order, they rejected your petitions.
2 petitions.
The notice was issued? Notice, page? Annexure 5.
Annexure 4 and 5, my lord.
ତାହେଲେ ସେଟା କରେକ୍ସନ କରିବାକୁ ପଡିବ ଆପଣ ଆଉ ଥରେ ଡାକନ୍ତୁ ପ୍ରଥମରୁ ପଢନ୍ତୁ ନାଇଁ ଆଗ ଲେଖନ୍ତୁ ଦ notices dated 3rd of August 2024. Both the notices are 3rd of August.
Yes, ma'am.
The
One under
notices,
section 91, one under 91, 92.
August ତାପରେ ପଢନ୍ତୁ 3rd of August 2024 ତାପରେ continue reading ପଢନ୍ତୁ ନହେଲେ କାଟିକି ଲେଖନ୍ତୁ ଯଦି difficult ହଉଛି ପୁରା କାଟି ଦିଅନ୍ତୁ. It is submitted by the learned counsel for the petitioner that the petitioner is aggrieved by the notices dated 3rd of 2024 purportedly issued under section 91 into bracket 1 of Orissa Development Authority Act -1982 for violation of provisions under section 15 of the said act, and the notice to stop construction under section 92 into bracket, this is Roman 1 or English 1?
No, English one.
Tabi bhul likha hai. Under section 92 into bracket Roman English 1 and section 92 joti jaldi hi jo mate kahibe, so I'll slow down. Section 92 into bracket English 2. It is submitted that the use of power under the Orissa Development Authority Act has been made as mentioned in the order dated 20th of December 2024, that the municipal corporation has been empowered by notification number 10975/CDA dated 22/8/2019 10975/CDA dated yes. It is further submitted that the petition filed by the petitioner in the form of preliminary objection into bracket annexure 6 and annexure 7 have been rejected without considering the matter in its proper perspective, inasmuch as the complainant at whose instance the proceedings were initiated is not a necessary party in the proceeding before the authority. Issue notice along with this order to the opposite parties. The learned AC appears on behalf of OP numbers 1, 2 and 5 upon advance copy served.
It's only 1 and 2.
Only 1 and 2, man.
अच्छा Deputy Commissioner Municipal, I thought police. I'm sorry. कौन लिख ले? 1 and 2 upon advance copy served, waives notice, let 2 extra copies be served on you don't require copies. The learned AC shall obtain instructions from the OP number 1 and 2. Issue notice to OP number OP's opposite parties 3 to 5 by registered speed post with AD. Requisites for issuance of notice be filed within 5 working days. Yes.
And I've also filed an IA.
Yes.
Stay of the UC proceeding.
লিখন্তু IA 1783 of 2025 had Learned Counsel for the petitioner. The submissions as noted above are reiterated. The learned AC accepts notice upon advance copy being served, waives notice, and appears on behalf of opposite parties 1 and 2. Issue notice as above to the opposite parties 3 to 5. Hela? Accept one set of process fee. Notice in the application along with the writ petition shall be served, shall be issued together along with this order, as directed above. As an interim measure, it is directed to further proceeding pursuant to the UCK, further proceeding in the UC case number 57 of 2024 shall remain stayed till appearance of the opposite parties 3, 4, and 5. Yes.
49 judge.
ମୁଁ କଣ ଡାକିଛି?
ହଁ sir, ସମାଧାନ।
ନେଇଛନ୍ତି ଠିକ ଅଛି।
50
Yes, Mr. Misra. Petitioner none. Ms. Das AC for the state. None appears for the petitioner when the matter is called to grant further opportunity. List after 2 weeks. Liberty to mention for listing before the assigned bench. Pass over ଡାକନ୍ତୁ।
sorry
ରିସେସ୍ ପୂର୍ବରୁ ସବୁ ଡାକି ଦେଇଥିଲେ କଣ? ମ୍ୟାଡାମ ଏ ଯିଏ ମେନସନ କରିଥିଲେ ଆଉ କିଛି ନାହିଁ, ଚେକ୍ କରିଦିଅନ୍ତୁ। ଯୋଉଟା ଆପଣଙ୍କର ଇଏ ଆକାଉଣ୍ଟାଣ୍ଟ ଜେନେରାଲ ପାଇଁ କିଏ ଆସିଥିଲେ? ସୁଧୀର ପାତ୍ର ଆସିନାହାନ୍ତି। ଥ୍ୟାଙ୍କ ୟୁ।